Good morning. The clock in the back of the room is inaccurate, so we're going to call this meeting to order on August the 18th, 2014 at 10:01 a.m. and ask Commissioner Hensley to lead us in the pledges of allegiance. Please rise.
I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Honor
the Texas flag. I pledge allegiance to thee, to Texas, one state under God, one and indivisible.
You may be seated. Commissioner Jones is out of town today. I would entertain a motion to excuse his absence.
Second.
No, I need the motion.
So, I move that we excuse Commissioner Jones' absence.
And now I have a second.
Second.
All in favor say aye.
Aye.
And opposed, no. Motion carries. Look, before we hear reports, I would just, if you're keeping up with these kind of things, we're going to move agenda item 26 right after agenda item 8 so that we can hear the audit report from Renee Gonzalez, and we will be consolidating agenda items 34 and 20 at the item 20 place. So now we will hear reports by the administrator, the general counsel, division directors, and other folks. First, Mr. Olmixon.
Good morning, Commissioners. Welcome, and thank you for your continued service to the people of Texas in your voluntary capacity as policymakers for this fine agency. We have had an extraordinarily busy summer, primarily finalizing the strategic plan and the budget that reflects its findings. Both of those are on your agenda for consideration and action today. You will also hear reports from the Budget Committee, the Executive Committee, Education Standards Advisory Committee, the Broker Responsibility Working Group, and the Inspector Advisory Committee, all of whom have had one or more meetings since the Commission's last meeting in May. You'll also consider a approval of a rewrite of the Broker Responsibility course that is proposed for your approval today. Also, we are completing today the proposal of the last set of rules to complete our statutory quadrennial rule review requirement. It has been a long and tedious but a very vital process. And so I congratulate you on having reached that milestone. And at the following meeting, hopefully in November, you'll be able to complete the adoption of those rules. We'll also hear an internal audit report from our auditors, Garza Gonzalez. There'll be, for your information, I know I sent this out earlier, there's a reconsideration by the State Auditor's Office of their audit findings due to some of the unique characteristics of SDSI agencies and the incredible complexity of this Commission's accounting. Just to give you a little taste of that, you know, we collect annually over $22 million, and all but actually less than $10 million of that is actually funds to operate this agency. All the rest of it is collected on behalf of other agencies and the general revenue. And keeping track of all that, Melissa and her staff do a fine job of it. But the oversight agencies are still in discussions about what the appropriate rules are for reporting all of those things. All of the dollars are there, just how do we, in what categories do we report them? A couple of other high-profile items. There's a proposal for reduction of the use of certain non-certified course delivery alternatives, and this is recommended for proposal today. So there will be an extensive comment period, and the Education Standards Advisory Committee will have the opportunity to further consider all of the many comments that we expect prior to your November meeting. There'll be a discussion today and possible action on developing market practices to ensure that clients are fully informed and that our fiduciaries live up to their statutory obligations. I'm referring to the agenda items on the practice of posting coming soon signs and the use of .realty domains for websites. These discussions are fully in keeping with the Commission's charge to protect the consumers of real estate services in Texas by ensuring both qualified and ethical service providers. Unless you have any particular questions for me, the division directors will now provide their regular quarterly update reports.
Any questions for Mr. Olmixon? Thank you, Mr. Olmixon. Ms. Deanda.
Good morning, Lori Deanda, Director of Reception and Communication Services. Before I get started with my report, I would like to introduce 3 new team members. First, we have Letitia Brown. Letitia joined TREC on July 9th as a customer service representative, and she has 10 years of customer service experience and is a mother of 6-year-old twins.
Wow. Wow.
Next, we have Christina Johnson. Christina joined TREC on July 7th as a customer service representative. She has over 4 years of customer service experience and enjoys reading, watching movies, and spending time with family. And the final team member is Karen Fisher. Karen Fisher joined TREC on July 7th as a customer service representative. She has earned a Bachelor of Arts degree in Communication Arts from the University of South Alabama and has over 10 years of customer service experience. And in her spare time, Karen enjoys playing tennis and volleyball with her daughter. Thank you. So please refer to the C1 report. For the month of June, we received 20,487 calls, bringing the fiscal year-to-date total to 171,837. We assisted 388 walk-ins, bringing the fiscal year-to-date total to 4,187. We responded to 6,339 emails, bringing the fiscal year-to-date total to 51,601. I also would like to mention that RCS has 2 part-time vacancies that are open with the shifts being from 10 a.m. to 2 p.m. to assist to have full coverage during lunch hours. And that concludes my report, and I'm available to answer any questions.
I'd like to make a comment. I think that your department, customer service, is the real essence of what TREC is about, because I think that is the real image. So I'm really pleased to see that you have such strong people that are going to be serving in that capacity.
Thank you. Thank you very much.
Do you have a comment? Commissioner Justice.
Yeah. Can you hear me?
Yes.
Okay. Yeah, I have a comment and a question. First of all, I'm thrilled to death to see that we have some additional folks coming in, and because communication is key, there's no question about it. This relates to a report I read in getting ready for this, and so I don't want to say, I can't remember exactly where it came from, but I just want a clarification. Response to emails, what I read in the report was 2 days. Mm-hmm. Can you just tell me if that means that the day the email is sent is day 1 and tomorrow is day 2? Or does it mean tomorrow is day 1 and the following is day 2?
Tomorrow would be day 2, because we would have today to...
Today would count?
Yes.
Okay. That is
It's in the strategic plan.
considerably improved from what we had been doing, and I think that's great. That's really helpful to the public. Thank you.
Thank you.
Commissioner Justice, I think that was a goal in the strategic plan.
Yes.
Yeah. Any other comments or questions? Thank you, Ms. Deanda. Ms. Jackson?
Good morning. Gwen Jackson, Director of Education and Licensing Services. First of all, we've got a new team member as well in the ELS division, and I'd like to introduce to you our new Education Specialist 2 team member. Her name is Jennifer Gruby. Jennifer recently completed her master's degree in education, and she has experience as a compliance consultant reviewing education materials with the School of Culinary Arts. She has education planning, organizational, and compliance skills, and we're fortunate that she's able to join our team. Today is Jennifer's first day with us. And I'd just like to say we now have a full team on the education side.
Bless your heart, Jen.
That's good. Amazing.
Next, if you would direct your attention to the L1 report. On the L1 report, the most significant observation is the almost 69% increase that we've had this fiscal year June compared with last June in sales original applications received. This increase in applications has resulted in almost a 31% increase in sales licenses issued for this period. If there are no questions, I'll move to the L2 report. And this report further reflects the increases that we're seeing in the number of sales applications and sales licenses issued. In June 2013, there were a total of 96,202 active and inactive salespersons. This June, our total was 104,023, which is an 8% increase over last June's totals. In June 2013, we had a total of 141,071 brokers and sales licenses, which has increased by over 5% to a total of 148,757 this June. We have 3,031 inspectors and 1,985 easement and right-of-way registrants. Our total licensee and registrant count this June is at 153,773, which is a 5% increase over our total of 146,329 last year. If there are no questions, we move to the L3 and the L3A report, which is our reports on our examination activity. Our first attempt pass rates are slightly lower, but not significant enough to be concerned about. If you will recall, Pearson VUE will become our new exam administrator effective September 1. And we've been working with them during the last few months to ensure as smooth a transition as possible. Exam content outlines have been shared with our qualifying education providers, and information has been provided in the advisor publication and is accessible through the Pearson VUE website. Pearson VUE test centers will be available to take registrations from exam candidates by telephone on August the 28th and by website October the 29th. Moving to the L4 report, we have a total of 4,784 approved instructors, which is an increase from the 4,664 that we had last year, June. Are there any questions?
Thank you, Ms. Jackson. Mr. Moore.
Hi. We've also got one new employee, Stella Prejean. She started with us on June 1st as a legal assistant. She's got a pretty interesting background. She was a legal assistant in private practice and has also practiced real estate in both California and Texas. So I think she'll bring a pretty interesting and unique perspective to the job. Thank you, Stella. On the first report, this is the case status report. We have almost a year. We have some good news in one area that's cause for concern. The cause for concern, as you can see, for 4 straight months, we've had over 200 cases open. By comparison, the previous 3 fiscal years, we had 4 total of months where we had over 200 cases open. This isn't really bad news because when people have good and valid complaints, we want them to file them. I think it's more a reflection of the market being a bit stronger in Texas. The reason why it's a cause for concern is because you want to make sure you have adequate staffing for it, and of course that you want to process your complaints timely. And we have good news on both of those areas. As you can also see, for 3 straight months, we've closed over 200 cases. So our productivity has been really good during that time, and we're pretty proud of our staff on that. Moving to the open case aging report, this also has good news. It's also the other part of the equation. You want to process cases, close cases. You also want to do it timely so that justice is served more quickly. At the start of this fiscal year, we had about 87% of our cases were less than a year old. That's not bad, but we want it to be kind of over 90%. Right now it's at 96%, so we're pretty happy. We think that's pretty good to have that many cases closed or open within the first year. We don't know if that'll last. I think some of that has to do with the fact you have a lot of new cases, so of course those are going to be within a year. But those numbers are pretty good. We have 6 cases that are over 2 years old. 3 of those are a PFD that will be heard today. 2 of those we had a decision where a respondent requested a hearing, did not show up for the hearing, so those have already gone final. And then 1 is set for hearing November 18th. Once a case gets into the SOA process or contested case process further on, we don't have as much control over the timing, but still those cases we do want to resolve. The third report is the complaint subject categories report, and for the first time we now have a year of data.
Right.
And so that we're probably going to do a rolling year on that, so you always have a year of data to look at, and of course that makes the report more useful. Do you all have any questions on either of any of these 3 reports?
Yes, I have a question on the complaint subject category. Just looking at it from leasing/property management, and one is a misappropriation, and then leasing property management. We're looking at almost 20%. What is it that is so unique about having those number of percentage of complaints? And I guess as a follow-up, is there anything that we can do to reduce that number?
Yeah, the first part, this seems to be, we didn't have hard numbers really until the last year, but anecdotally it seems to have been high for many years. Leasing and property management is a little different from some of the other areas. You have less checks and balances. You don't have title companies involved. You don't have 2 opposing sides typically. A lot of times in property management, one of the key parties isn't even present. They're often out of state. Maybe they're deployed overseas, and then you have people handling money every month. So there's a lot more potential for issues if someone has a bankruptcy or financial issues or is just negligent. So I think that's why that area is higher. As far as what we can do is, I think, and at least for the standards enforcement services, is continue enforcing the law and getting results. And we've had a lot of cases on this in the last year or two, actually with some of them involved anywhere from 5 to 20 complaints. And those are being resolved, and there's been, I think, justice served on those.
Commissioner Alley and Mark, also, I'm sure you noticed in the new broker responsibility course, there's a lot more beefed up section on property management to attempt to hit it at in another direction than, with enforcement, but with education.
Right. Yeah, and that's a good point, because education's the other part of it. I always see the bad stuff, and of course if you can head it up at front with good education, that's pretty key too.
Madam
Chair.
Sir.
Last month I was involved in a national brokers training meeting, I guess, course to be there. And it looks like 50% of the complaints of other states are on property management. And they were extremely concerned. And I thought we were doing extremely well, but you're right, 20% is not even good enough. In enforcing what we have, it's not going to work. We have to go back and figure out what to do to make sure that the public is taken care of. And we all know what the rules are. We just like to bend the rules because it's so simple to do. If we do not have thresholds that are going to be accountable, it's going to continue, and it's not desirable. So we need to go back, and I know the brokers are responsible, but even then, that is not helping. So we need to figure out somehow, what can the legislature do to make it a bit more difficult. Thank you.
Okay.
Thank you.
Anything else? Thank you, Mr. Moore. What have I got? Did you have another question for him? I'm sorry, Mark.
You know, on the report, I'm thankful that we've finally gotten to a year's worth of data on this. On the backside, of course, it has the complaint subject categories by month. But I was wondering on the pie chart if we could at least maybe take some of that information from the back and put it on the front, so that way we can just see, you know, here's the top 2 reasons under administrative, here's the top 2 reasons under broker supervision, and I think that'll just give us the composite snapshot to know, as Commissioner Ayaga was pointing out, where we go from here and how we correct it.
So what specific change would you want on the pie chart?
I want to see the top 2. I want to see the top 2 reasons in each category on the pie chart.
So let me be sure.
what I'd like
I
to
understand.
request.
Like under administrative, you would put whatever it is. It's like a little footnote
Yeah,
over
because,
there.
you know, essentially we want to get to a root cause analysis, correct? And you already are doing that, I'm sure, which is why we get resolution in the overall scheme of things. But from us, you know, since we're not working the cases every day, it'd just be nice to see what that root cause analysis was, again, so that if we see opportunity to drive change in other areas, it'll just give us a more 3D snapshot. Thank you.
Is that it? Okay. Let's try again. Mr. Watson.
Good morning. I'm Tom Watson, Director of Information and Technology Services. If you could turn to page I-1. On I-1, we continue to see consistent results on the website utilization, both in terms of unique visitors as well as pages viewed in comparison to last year at this time. For the online transactions, we continue to see strength on the initial applications compared year over year, and the renewals are consistent with what we've been experiencing over the past year. So on both counts, I think very positive numbers. The sponsorship transactions, too, we're seeing pretty strong numbers compared to last year at this time. So that's another positive sign of usage of our website. On page I-2, the only thing I would like to point out is the middle chart there for the renewal services. Over the last 2 months, it does appear to be a significant drop in trend, but that is coming off of high numbers. And if you look at the actual numbers and compared them, what you would see is actually consistency over the longer term. And it does not really appear to be a trend at this point of declining usage. I'll be happy to answer any questions you may have.
Any questions for Mr. Watson? Yes. Commissioner Arriaga?
Tom, where are we on going paperless, on scanning and having anything online?
Right now, we have approximately 2 million documents scanned. The last estimate that I put together, we have about 600,000 to go. Our objective is to complete that latter part of this year or early next year.
And then we're going to throw away all the paper?
We have been eliminating paper right now in terms of once they are electronically scanned and they are properly QA'd, then we will dispose of paper accordingly. We are at this point focused mainly on the master licensing files. So once we do get it all scanned, then we can toss and get rid of that paper and free up that space.
So by the end of the year, we'll be completely paperless in terms of storage?
That is our objective for the master files.
Okay. Thank you.
Any other questions for Mr. Watson? Thank you, Tom. Ms. Huerta?
Good morning. I'm Melissa Huerta, Director of Staff and Support Services. And I'm going to be talking to you about the TREC budget status report as of June 2014. So on the status report, there's just a few items that I wanted to point out. One of them on the expenditures on the professional fees. We have quite a bit still remaining in the budget, 66%, but that's due because some of our professional services, such as the internal audit and the website redesign, are being paid in July and August. So the remaining budget will be decreased. Another line item on the office rent. As discussed in previous meetings, the rent has been paid in full, but it was reduced due to the SWI cap cost. So then the other line item would be the SWI cap cost, and it is extremely out of proportion, and that's because of the costs that were allocated to us for the Stephen F. Austin building, our space here in the Stephen F. Austin building. And then the last item under expenditures are contributions to the general revenue. That's going to be paid this month. So throughout the year, it's just been allocated as a cost, but we're actually going to pay the expense in this month. So we'll be giving $720,000 to the General Revenue Fund. On the revenue side, our revenues are doing really well, and we're actually on track to exceed our revenue projections for 2014. And it may be a little, you can't quite see it on your page because of the numbers, page numbers on the bottom, but our actual balance is $1 million, our revenues over expenditures for this year, $1,203,532. Is there any questions on the budget?
Mr. Arriaga?
Ms. Huerta, I was trying to compare page 23 with the items 23, 24, and 25 in the packet on the budget. And I could not get the numbers to transfer over because I guess the budget is being annualized and this one is just prorated in
Yes,
terms of
sir.
time?
If you look at the budget for fiscal year 2014, that first column, yeah, that's the same that's going to be on the budget when we're proposing the budget for 2015. Is that what you're talking about?
Okay, so the budget for 2014 at the very bottom on page 259 should equal that number, and it does.
Okay.
Thank you.
You're very welcome. Any other questions on the budget? All right, the next report is the S2 report, the Recovery Trust account. You can see on this report that our cash balance is $1,209,627.93. Our investment balance is $749,126.09, and the total balance in the account before you take in the reserved amount is $1,958,754.02. We currently, as of the end of June, had 671 reserved for potential payments within 90 days, but at the end of July, we closed out some contingent liabilities, so our balance is actually closer to $600,000 at what's reserved for 90 days. So that leaves us a balance at the end of June of $1,196,944.02. Any questions? The next report is also on the Recovery Trust. And the things I just wanted to point out would be the payments to date for fiscal year 2014, $294,428.38, and that's for 12 claims for this year, which is down quite a bit from previous years. The next report, the S4, is a Real Estate Inspection Recovery Fund report. And on this report, you can see our total cash is $53,595.01. We have reserved for payments within 90 days, $20,500. We do have some monies in the investment balance of $562,001.50. So our balance after reserves is $595,096.51. Are there any questions on that report? Okay, that concludes my reports, except for I just wanted to mention that there was an SAO report that came out. It was Compliance with Public Investment Act, and you received it on July 31st. And I just wanted to let you know that the report, it's not in your materials, but the report states that the agency was not in compliance with the PFIA training requirements. This was based on fiscal year 2013, and at that time, there was one commission member and myself who didn't take the training within the 6 months. That commission member did complete the training on June 2nd of 2013. I completed the training on August 26th of 2013, and so we are in compliance with everything that's required of the PFIA. Any questions?
Thank you. Ms. Huerta.
Thank you.
Commissioner Martinez, you have a Budget Committee report?
I do. I do. Thank you very much. At this time, we'd just like to, from a high level, let you know that we've complied with all of the requirements to have a public meeting, public hearing related to the budget process. Very good comments were received. The working group, accompanied by Commissioner Hensley, somebody else calling about the budget. And also Commissioner Alley worked alongside with Director Oldmixon and the staff to scrub the budget, and we'll be going into greater detail later on in the meeting. If any of the other committee members would like to add anything, certainly feel free.
Anything you'd like to add?
Well, I may save my comments to when he gets into detail. Thank you.
Thank you.
Thank you, Commissioner Martinez. The Executive Committee met earlier this week and discussed several items which are on the agenda in different places. And when we come to those items, if I need to, I can tell you what the Executive Committee thought. That concludes my report, and I believe Ms. Lewis is going to make the report for the Education Standards Advisory Committee in the absence of the chairman.
Good morning, Carrie Lewis, General Counsel. This report, Susan Jones could not be here today, and so she asked me to give this report on her behalf. The Education Standards Advisory Committee met on July 8th. Many stakeholders, including trade associations and educational providers, were present at the meeting, and their input was much appreciated. The committee completed the review of reorganized and updated education rules presented by staff following the staff's quadrennial rule review for Chapter 535 and prior policy recommendations offered by the Education Standards Advisory Committee. The committee recommends that the Commission propose new subchapters F and G as presented in your materials today for publication and public comment. The proposed rules reorganize the existing rules to better reflect Commission policies and approval processes for providers, courses, and instructors, and to improve readability and understanding. Most of the proposed rules contain the same requirements as in the current rules, although there are some substantive changes which are outlined in your materials for that agenda item. The most hotly debated change that the committee has recommended is to not allow correspondence courses as a delivery method for both qualifying and continuing education courses after December 31st, 2015. This decision was not made lightly. The committee debated this issue over several meetings and considered alternatives and comments from education providers and license holders, both for and against. Correspondence courses seem to contribute to many of the problems with education that the Commission originally charged this committee to study. Correspondence courses are currently offered in association with colleges and universities and are required to be offered in accordance with the college or university's curriculum accreditation standards. However, because most are not part of an academic program, the courses do not receive any oversight or review other than TREC's review that the course contains the appropriate content. This lack of oversight results in correspondence courses that can be completed in a fraction of the time of the course's credit hours, no true verification that the student mastered the materials, since the final exam questions are sometimes given together with the course material, and there is no system to verify that the person taking the course in the exam for the course is the person who receives the credit. This is not what was intended when the rule allowing correspondence courses was put into place. Ultimately, the committee decided that eliminating correspondence courses as a delivery method would increase the quality of education for license holders, which in turn will provide greater consumer protection. The chair wanted me to make it clear that the Education Standards Advisory Committee is not recommending the elimination of all online courses. Under ESAC's proposal, delivery methods will be available as classroom, which by definition includes live webinars where the instructor and student can see each other via computer or other technology, and alternative delivery, which includes online courses as well as any other method other than classroom delivery, so long as that course has been certified by a distance learning center acceptable to the Commission. The Commission rules today currently provide for this delivery method, and there are courses that are approved today under this method. IDEC is the approved certification center by the Commission right now and reviews the courses and certifies the quality of the design and delivery, including that the course is designed for mastery-based learning, verification that the average time it takes a student to complete the course is the number of hours assigned for credit for the course, and that a procedure is in place to authenticate that the person registered to take the course is the person taking the course and final exam. IDEX stopped certifying correspondence courses in 2009 due to problems with verification of the quality of design and delivery for correspondence courses. Another new change in the proposed rules involves required instructor training for all pre-licensure and non-elective continuing education courses. Under the proposal, beginning January 1st, 2016, those instructors will be required to complete at least 8 hours of adult education instructor training that is acceptable to the Commission within 5 years. So every 5 years they would have to repeat that training. The committee's goal is to have instructors who are better able to deliver the required materials in a way that increases student comprehension and retention. The next ESAC meeting is set for September 30th, 2014 at 10 a.m. At that meeting, they will review comments received on any revised education rules proposed by this commission, review the requirements for instructors of pre-licensure courses, and develop guidelines for acceptable courses for instructor training for presentation to the commission at a future meeting. They continue to appreciate and invite stakeholder participation. That's the report.
That's the report. Are you also making the report for the Broker Responsibility Working Group, Ms. Lewis?
I am.
Perfect.
This report was approved for presentation by the chair, Mac McClure. The Broker Responsibility Working Group held a meeting on August 5th, 2014. The working group recommends revisions to the current point system used to evidence experience for a broker's license as presented in your materials under Rule 535.56 in Agenda Item 18. These revisions address fairness concerns in relation to commercial transactions, property management, and other miscellaneous transactions. The proposed rule and form revisions also require the applicant to include a log identifying the properties for which points are claimed. The group did not feel that this would be an undue burden since most license holders keep or have easy access to such records currently. The group reviewed a proposed realty chain of command contact information disclosure, and although the group liked the concept, they thought the information could be incorporated into the text of the IABS. The group understands that the text of the IABS is statutorily dictated, but believes a revision to update that text is long overdue, and with the Commission's consent, would like to attempt a revision. The group also discussed issues surrounding minimum services requirements for brokers and issues with rent-a-broker scenarios, including both the situation where one broker acts as a designated broker for many entities, usually owned by sales agents, and an out-of-state broker conducting Texas transaction through a Texas broker for a fee. The group will continue to study these issues, including a possible consumer disclosure regarding minimum services, and may bring a recommendation to the Commission at a future meeting. Finally, the group reviewed the proposed strategic plan initiatives as they relate to broker responsibility issues and was in agreement with all of them. The chair noted that he would like to encourage the Commission to make the working group a regular committee of the Commission to allow for continuous monitoring and vetting of new ideas regarding broker responsibility. The next meeting for the group will be scheduled for October 28th. Some of the items to be considered are formulating a required consumer disclosure regarding minimum services for brokers, and revising the text of the IABS required notice for consideration by the Commission as a possible recommended statutory change. That ends the report.
Thank you, Ms. Lewis, and please tell both groups we appreciate all their hard work. I don't believe Brian Murphy, chairman of the Inspector Committee, is here, but looks like we have Mr. Reinhardt coming down to make a report on behalf of the Real Estate Inspector Committee. Thank you.
Good morning. Stephen Reinhardt. I'm currently Vice Chair of the Inspector Advisory Committee and Chairman of the Education and Training Subcommittee. After kind of taken a breather for this last year on some of the volatile subjects. We've come up on a couple of things that have come up that have kept us real busy. We have recently started the, I guess you'd call it, biannual review of the standards of practice. We did it a couple of years ago, finished it, went through because of changes in practice in the industry and some things that we saw from the last one. The review of the standards of practice has started again, looking at a 12 to 18 month process. So they'll be keeping busy on that. From the training and education side, we've been attacking a number of problems. One that seems to be probably a big topic for everybody is the quality of training. We've always identified that we've had an issue with quality of training. We have discussed a lot about the proposal on the real estate side with the correspondence courses, and prepared to very actively try to exclude the real estate inspectors for a number of reasons, which we can address at that appropriate time.
Any questions?
But those are the two main things that are happening.
So you're going to be here for the day?
Yes.
Okay. Anybody have any questions for Mr. Reinhardt? Thank you for your report. As mentioned earlier, we have moved agenda item 26 to this place, and we would ask Renee to come forward and make the audit report, which is, the report is on page 263.
Thank you, Madam Chair, Commission members. My name is Rene Gonzalez, and I'm the senior partner with your independent internal audit firm, Garza Gonzalez and Associates. And as the chair has indicated, on page 263, you will find the annual internal audit report that's due to the different agencies, Governor's Office, State Auditor's Office, and LBB by November 1st. So you'll be meeting that specific deadline. The audits that are included in this report are the audits that you as a body approved for us to perform pretty much at the outset of this particular fiscal year. And that was in the education program monitoring, the recovery fund audit, and time-sharing registration. And we work very closely with your staff, primarily, of course, Melissa, Gwen, and Mark, aside from other individuals that we interviewed and gathered information during the time that we were here performing the audit. Based on that, this report complies with the State Auditor's Office and the Texas Internal Auditing Act. Once hopefully it gets approved by this body, we'll then submit it to those agencies that it needs to be there, like I said, by November 1st. I'm happy to report that we had full cooperation from your staff. They provide us with information. The audit can be performed without their assistance, and we had full cooperation and no restriction of any scope as far as we're concerned. And they, of course, acted in a very professional manner, and we appreciate that, just like they have always. The report itself is, as I indicated, starts in your paging number, page 263 through page 287. And I'm happy to report that we did look at the report outlines all the different areas. I'm not going to go through each one, but just to share with you that in the educational program monitoring function on page 274, we outlined for you our different procedures. Of course, those start out on page 273, our audit scope, what we did, et cetera. But primarily to share with you that in this particular area, we selected a sample of applications to determine that the rules, regulations, policies, and procedures for processing the applications were consistently applied, and that the required documentation and application fees were collected and reported. And I'm happy to report that in this particular area, you'll find that in a subsequent page here in our report, is that we have no observations or recommendations, meaning to you that we feel very comfortable with the things that we tested, that we reviewed. Again, we don't look at 100% of your transactions, but we select a sample, we select what we're going to look at, and we had no particular recommendations or observations in that particular area. In the second area, the recovery fund, which includes the inspection and the real estate funds, we also looked at that area based, again, on your direction on page 275 under audit scope. The last 2 points basically telling you that, of course, we looked to determine whether the established internal controls and administrative practices or implemented and consistently applied. In addition to that, we perform an analysis of the activity and balances of the recovery funds, both the inspection and the real estate, to determine that the funds are properly and consistently managed and with respect to the applications, laws, regulations, and rules. And again, in that particular arena, that particular area, there's no observations or findings. And that you can find, if you wanted to flip through that, but we can go through that later, would be on page 283, where we show any recommendations or observations. The last area that we looked at is the time-sharing registration. And in that one, you'll find that at the bottom of page 275 of your pages. And in there also, we outline the background of the area, what our scope was. And in that particular case, we looked and obtained a listing of all your applications to register new timeshares and renewals of timeshares. And based on that, of course, the objective there was to determine and ensure that the required documents were all obtained, ensure that the collection of the filing fee was collected, and ensure that the laws, regulations, policies, and procedures for processing the timeshare plan registration were consistently applied. In that particular area, we have one observation. It's observation that, of course, we've discussed with management, and their response is included on page 283. In that particular case, all we're sharing is that there are some requirements, and we just wanted to be a little bit more, I guess, provide that information more to the person, that the Texan that would be investing in these things, that they understand, and that you include it in your website where they are required or can require certain information from the particular vendor of the timeshares. And those are outlined on page 283. Again, we're basically saying the observations to enhance public awareness, and maybe you ought to consider posting that in your web so that your constituents can look at that and determine that they do have a right to request certain information. And management has agreed with that particular area. In addition to those three areas that you asked us to perform, we also do a follow-up. The follow-up you'll find on page 284 and 285. We had 2 from 2012 that were still carried forward, and 2 from 2013, and all those are implemented as of the date that we completed the report. So again, a very positive report, had full cooperation from your staff. On page 286 of the report, and by the way, this report is structured by the State Auditor's Office. So every audit report you see for any state agency is going to follow this particular format. That last, on page 286, the proposed internal audit plan, Roman numeral 8, that's what we feel are auditable areas for this coming year. But we still are required by the Texas Internal Audit Act to perform an assessment of risk over the last year. We do that on an annual basis. We'll come back, and we may propose these or may propose different areas depending on how the risk factors fall out. But they want to have an idea of what are the areas that you may be looking at in the subsequent year, because they do an overall planning for the state as a whole. So just to share that that's in there as well. And other than that, I'd be more than happy to respond to any questions you may have. I apologize that Richard Galindo, who you're used to seeing here, our audit manager in this particular engagement, had some minor medical procedures, so was unable to be here this morning. But I'm glad to be here myself.
Thank you. Commissioner Arriaga.
Madam Chair, in looking at page 286, talks about proposed audit, internal audit plans, I guess.
Yes,
Two areas, don't know whether this is the forum that I think we need to focus on, if this is the correct place. One is on property management. And if nothing else, the only thing I can come up, and I'm not the brightest person in the world to understand how the system works, but if we can have some kind of mandatory education necessary for anybody who wants to do property management, we have to do something to protect the public. It's not being done. Number two is, one of the biggest sins is that the public is getting inaccurate information on real estate from the web. And I'm not pointing fingers at Zillow or Trulia or anything like that, but we need to make sure that if there's any information out there in the state of Texas, that the public is protected. Don't know whether this is the correct form or not, but that's something that we need to look at. Thank you.
And I think that's proper. I mean, our firm gets our directions from you, our commissioners. We work for you, and if there's any particular area, you know, we're happy to look at that and then come back as part of the audit plan.
By when and who makes that recommendation?
I think we today will be agreeing with or modifying their proposal. Is that correct, General Counsel? Yes.
If I'd like to recommend, if possible and if proper, that we look into property management and more education, even if it's mandatory to real estate licensees, as well as accurate information on the web on real estate.
Commissioner Westcott.
Yeah, do we have a sort of consumer-friendly, fact-based, basic facts about Texas real estate website?
Commissioner, the one area that our website has consistently fallen short is the quantity and timeliness of data provided to consumers about this market. We do have links to information. Probably the most authoritative source in the state of Texas, the Real Estate Research Center at Texas A&M. But we have not, to date, we have not translated that data, if you will, into much more user-friendly, bite-sized chunks. That is an objective for the agency's new website, which will be rolled out next year.
You're talking about market data.
Correct.
Okay.
Yeah, I'm more talking
about something else.
Like the very basic, I'm a first-time home buyer. I've never bought a house before. What do I need to know about a real estate transaction?
There are actually two different first-time homebuyer guides that are linked on our website. But as I said, they're done by others, so we provide them as a resource. But I think we could do, and I think we plan to, do a much better job of digesting that and re-messaging it, if you will, so that it's aimed at our audience a little more directly.
Did you want to speak to property management and other stuff, or are we just going to add it?
Well, I was going to say there is an opportunity during the risk assessment that the internal auditors will be doing next spring to add in, if we direct them to add in topics, then they'll have to figure out exactly how to do that, and then how to do that. It's part of their risk assessment, is whether or not there's adequate authority, responsibility, and data to analyze what we might possibly do there.
Exactly, that would be the process. I mean, I don't anticipate or recommend that we modify this report as it is, because again, that's based on what we know from the risk assessment we did last year in the areas that we covered. But exactly what Doug is saying is that we would move forward in that area and contact commissioners and find out if there's other specific areas we can include in here, or if there's a committee that we can report directly to, that would work as well.
Go ahead. I want to
one last item, and I hate to just jump on the bandwagon, but the biggest concern in my area, or the biggest complaint when people come to me, is on actually complaints from the public. Our process is cumbersome. It has to be in writing, it has to follow a certain process. It has to be, because we don't want any Tom, Dick, or Jose just to start pointing fingers. But we need to be nimble in terms of responding to abuse of the public. Our system is not that friendly, and don't know when was the last time it was looked into. So at some point in time in the next year or so, I think that'll be on our agenda. Thank you.
Commissioner Arriaga, this is a proposal for these guys to work on this in the future, and some of the things that may need to be done on property management might need to be brought to the legislature in January. So it might be, it's certainly a good idea, but we may want to take action sooner than that. Just a comment. So what are we doing here? making a motion to approve his report with the addition of property management as a potential examination audit.
Approve the audit report?
As presented.
As presented.
Second.
Have a motion and a second. All in favor say aye.
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 And opposed, no. Motion carries. Thank you.
Madam Chair. Thank you, appreciate it.
Agenda item 9 is general comments from visitors on non-agenda items, and I have one person wishing to speak at this time, Mr. Baker.
Good morning, Commissioners. Try to keep this very, very brief.
I forgot to tell you, 3 minutes.
Yes, ma'am. Try to keep it under that.
Okay.
Specifically, what I want to speak to is the 9 hours of MCE credit requirement for every renewal period. Not that it's required. There's no rollover from any additional hours from a previous renewal period. For example, pull up my little chart here. In 2010, I have 135 credit hours. 2011, 54. 2012, 270. That's 459 credit hours. Yet, when I renew here in February of 15, I have to take another 9 hours. Now, the reason I had all those hours is because I've earned my broker's license, CCIM designation, and my master's in real estate from Texas A&M University. Yet I need to go take another 9 hours. At this point in my education, the only coursework available to me that is practical and helpful to continuing my professional ventures are courses that are 15 to 30 hours long, cost many hundreds of dollars, up to $1,500 or $2,000. However, if I take one of those 30-hour courses, I have to throw away 21 hours of that because none of it will roll over to my next renewal period. I question that there may be an oversight. While it seems the Commission has done a great job of setting mandatory minimums, we may have oversighted incentivizing men and women to go above and beyond and really push their education. At this point, between now and February, I'm faced with this decision. Do I take three 3-hour courses? They're absolutely worthless to me. They're the bare minimum. They'll cost me about $100. And I can check all the boxes and I pass it and I renew. Or do I go take another 30-hour course that's actually practical for me, but 21 hours of that is junk, except it helps me, but it's not credited anywhere. I have 459 hours in the past 3 years. Additional to that, I have another 270 hours that should easily be counted because they were directly in the Master of Real Estate program, but they do not reflect within my education. All I ask is that there's some revisiting, possibly, and some incentivizing for the men and women of Texas that hold licenses to do a better than minimum. Because the current rules only set the advantage to do bare minimum and nothing more, and in fact punish those of us that have gone above and beyond. And there's no retroactive for those of us like myself that are now facing 9 additional hours, and it falls to one extreme or the other. Do I go the bare minimum in the cheapest route possible in the least amount of time possible? Or do I actually spend a bunch of time learning something that's really practical and helpful, but most of that's going to be wasted, except for my own benefit?
Mr. Baker, thank you.
Thank you.
Thank you. Okay. I believe we are going to adjourn into executive session to discuss pending litigation or obtain legal advice of our counsel pursuant to Texas Government Code 551071. The time is 11 o'clock. I believe this will take us at least an hour. Thank you.
ALJ Roy Scudday. The ALJ issued a PFD finding that the evidence established multiple counts of multiple violations of the Real Estate Licensing Act and Commission rules. The ALJ recommends that Ms. Williams' broker's license be revoked and that she be assessed an administrative penalty of $44,000.
Thank you very much. Is there at this time, oh, I'm sorry.
He wants to present the case.
Yes, sir, please.
Good afternoon, Mark Moore, Standards and Enforcement Services. We agree with the proposal for the decision and recommend its adoption. If you have any questions about the case, we have the attorney on it, Sharon Harris.
Any of the commissioners have any questions for Mark or for Ms. Harris?
Oh, and the respondent is not present.
That was my next question. Is I'm going to go ahead and ask, is the respondent present, or is anyone representing Ms. Williams' interest present today? Okay. In that case, I will, at this time, if the commissioners do not have any questions, I'll entertain a motion to accept the proposal for decision from our friends at SOA.
Yeah, I'd like to move to accept the decision from SOA.
We have a motion. Do we have a second? Second. All in favor, say aye.
Aye.
Any opposed? Okay, moving on. Agenda item 11B, consideration and possible action regarding proposal for decision in the matter of docket number 329-14-2386.REC, Texas Real Estate Commission versus Robin Roger Hawk. Ms. Lewis?
Yes, this case involves the denial of Mr. Houck's application for reinstatement of his broker's license, which was revoked in 2012 following payment from the Recovery Fund. Before he applied for reinstatement, Mr. Houck did repay the amount from the fund. However, based on the underlying complaint from that action and the fact that Mr. Houck failed to disclose on his application that he had a mortgage broker's license and that he had been disciplined by the regulatory agency for that license, staff denied the reinstatement on the grounds that he did not possess the requisite honesty, trustworthiness, or integrity to hold a license. A SOA hearing on this matter was held on May 7, 2014, before ALJ Beth Bierman. The ALJ issued a PDF finding that the evidence established that Mr. Houck did not currently possess the requisite honesty, trustworthiness, or integrity to hold a license. The ALJ recommends that Mr. Houck's application for reinstatement be denied.
Mr. Morris.
With this case, we do agree with the proposal for decision and recommend its adoption. The attorney on the case, Sharon Harris, is here to answer any questions. Mr. Hawk is also present, and he was unsure if he wished to speak, but I did let him know that that's his option.
Okay, do you have any further presentation you'd like to make this time? Ms. Harris, do you? Are there any questions from any of the commissioners for our legal staff? And is it Mr. Hawk? Am I pronouncing that correctly, sir? Houck? I apologize. Mr. Houck, I'm going to provide you with 5 minutes, okay, sir?
That'll be fine. Thank you very much. We're here because of a house that I sold back in, I think, March of 2006. After I sold the house, about a year later, the occupant complained that his sewer was not working correctly. He had a septic system, and it was overflowing after a heavy rain. So we went out there and tried to fix it. I offered to fix it for him, but he had obtained an attorney, and the attorney said that they didn't want it fixed, they wanted money. So what happened at that point, the plaintiffs here sued myself, and I'll just read this from the court docket. On cause number 225173-C in the 169th District Court of Bell County, Texas, Vance and Cherie Morris versus Gale Rowe Realtor, DBA Century 21 Gale Rowe and Associates, Robin Houck individually, and DBA International Realty, that's me, plus Kimmett Barnett and Carla Barnett. The last two there are the owners of the property. They were sued also. They never did show up in court, however. They didn't show up for mediation either. They filed bankruptcy, and no one has really seen them since. The other party here, Gale Rowe and Associates, had an attorney, and they settled with the plaintiffs for $5,000 cash. So they considered themselves out of the deal. And of course, at the time, I was pretty ill, and I wasn't doing much work, so I didn't have any money. So I couldn't settle with them. And so then they eventually carried it forward to the 169th court, and they sued me for the money to repair this the septic system, which was, I think, $11,000. When we got to court, it was just myself and supposedly the Barnetts. They did not show at court. And so the judge asked me if I wanted to go ahead, and I just went ahead and said, okay, we'll do this. The problem with this case came because of the septic disclosure. And when you sell a piece of property, you have your property disclosure. If it has a septic system, you have a separate little piece of paper. It's called the septic disclosure. When I first wrote the contract, I got all the disclosures from the Century 21 people, and I gave it to our buyer, and they eventually signed it, and we turned it in. They did not, however, I'm talking about Century 21, apparently give the septic disclosure, this separate little piece of paper. And that's where the problem came in, because when we went to court, remember, I was the only person here present at the time in court. Their attorney brought these two pieces of paper, the septic disclosure in one hand and the property disclosure in the other hand. And guess what he brought? The main disclosure was totally unsigned. That attorney had went out somewhere and got the unsigned disclosure and presented the unsigned property disclosure along with the unsigned septic disclosure, and then and he used this deceptive practice to influence the judge. So that's what happened there. So anyway, The court found me guilty. I'm not sure exactly what the charge was at this point. But anyway, they found that I was liable for replacing the septic system. And so they fined me $11,000 plus attorney fees, which I think were $9,000. About 3 years later, after I'd tried to appeal this thing with the state, I got a letter from Miss Harris. Here it is here, and she said that the state had paid this claim because I didn't have the money to pay it, and they wanted their money, and that was fine with me. She also said that there was another complaint that the commission had filed separately, and that's probably in this document here. Anyway, this document that I got from Ms. Harris was dated March 7, 2012, and at that point, I told her that I wanted to go ahead and pay the commission. Didn't have any money because I was still pretty sick, and she said that's fine, except we're going to revoke your license if you don't pay us within 20 days, I think it was. So eventually we went to court, and I think it was October 25th of 2012, and the judge found that I didn't pay the commission this $20,000, which of course I admitted to because that's why we were there. It wasn't a secret or anything.
Mr. Houck,
yes, sir.
I appreciate all this background. We've far exceeded the 5 minutes that we were initially going to give you. I want to explain first of all, we're not really in a position here today to rehash the underlying case. I think that
I understand.
And even the revocation, that's sort of water under the bridge, and that's we're not going to second guess the judge in Bell County and his judgment or those legal proceedings. The decision that was made with regard to whether or not to reinstate your license at this time was made based on some other factors that we have not yet addressed. I think some of my fellow commissioners.
Address those real quickly then.
Yes, sir.
All right.
Well, specifically, why didn't you list the disciplinary action taken against your mortgage broker license or that license on the disclosure
I'm glad
forms?
you asked me that. In 2010, the federal government came up with a new program. They call it NMLS. And at that time, all mortgage brokers had to get a new license, complete with all the, applications and everything. There was a lot of new regulations. When they did that, they changed our license numbers. So this number that Ms. Harris is complaining about, that's my old number. That's always been there. It's been there since 2001, I think. So I did not feel to disclose this license because it's just a moot issue. It's not. It's completely inaccurate to say that. All you people up here who have mortgage broker licenses or real estate licenses know that they made that change. So I correctly disclosed my current broker license, and that's all I got to say on that.
Do you take specific issue, or is there anything you'd like to address specifically with regard to the findings of fact that were made by the administrative law judge that we're here looking at today, or the conclusions of law? Are there any of those findings that you specifically contest, that you have any additional evidence you'd like us to consider today? Tell me why our ALJ judge is wrong here, Mr. Houck.
Well, she's wrong because she used Ms. Harris's complaints here, which were based on not disclosing my broker license, which is just not true. you can't convict me of something and use false evidence to do it. It's just not right.
Anybody else have any questions for Mr. Houck?
Yes.
Commissioner Arriaga.
Do you have a mortgage license today?
Hmm?
You do?
Yeah.
When did you get it?
2010. We renew it every year. It's renewed through the end of this year.
Have you ever lost it or been taken away?
No, they've never done anything with that at all. It's perfect. I had a new inspection in May of 13. No problems whatsoever. My license is perfect. They love me there.
Mr. Houck, are you saying that you didn't, excuse me, are you contesting the fact that the ALJ found here that you had another mortgage broker license that did have discipline? Let me finish, please, sir. That did have disciplinary action taken against it at some point?
Well,
did you disclose that previous disciplinary action in your license application to TREC?
I don't know that that question was ever asked in the past, because it was just normal renewal. That was just an administrative penalty, by the way, those things, and they were actually, the problems were created by people that worked for me. And of course, as the broker, I was responsible and had to pay that fee, but I didn't, it was other people that actually did that paperwork. We're just talking about an inspection of mortgage records, files. By the way, I'm a member of the Better Business Bureau with an A+ rating on the mortgage site, and I've been with them affiliated since 2005.
Is there any specific reason why you failed to repay the trust account for 4 years or so?
In 2008, I became incredibly ill, and I was unable to work for any lengthy periods. I went to the VA hospital, and they fixed me up after a few years. So I'm in pretty good shape today. But I was wounded in combat, and all that stuff came back to cause me a lot of problems. And for about a 5-year period, I could only work part-time, and sometimes I couldn't go to work.
Would your response be the same for why you didn't provide information that the commission requested for over 2 years after it was requested?
It was, I talked to Mrs. Harris about this. Also, I wasn't in the office 90% of the time from about late 2009 through most of 2012.
Okay. Anybody else have any questions?
I'd like to hear from Ms. Harris, just her take on it, and thank you for what you said.
Thank you, Mr. Houck.
Thanks, sir.
Ms. Harris?
Hi, Sharon Harris with the Real Estate Commission.
Oh.
Yeah. Did you have anything
Yeah.
specific, or would you like me to?
Several things, but why don't you go first?
Okay. We did have a full evidentiary hearing on Mr. Hawk's application for a license. The issue for an application for a license at any time is the issues of honesty, trustworthiness, and integrity. It is the applicant's burden at a hearing, well, before that, to satisfy the commission as to those three requisites, the honesty, trustworthiness, and integrity. Mr. Hawk did give us information about his past. For example, he'd had a license for about 23 years before it was revoked, that he had no other complaints at that time. But unfortunately for Mr. Hawk, there was that complaint that was filed. There was the incident that led up to the civil judgment. And with that said, we had to look at Mr. Hawk, especially from that time period forth, today. What does Mr. Hawk, what does he do to show us that today he has the honesty required, the trustworthiness, the integrity for this type of license, you know, with the state giving somebody the privilege of a license, but for this incident in the past, which usually we hear about other people's past, you know, who are they today? We got nothing from Mr. Hawk at the hearing. In fact, the judge, the administrative law judge Bierman, stated what Mr. Hawk gave us. And what he gave us was he blamed his own clients because they wanted money for that judgment. He blamed the listing agent, who we also had actually investigated and found insufficient evidence of any violation. He took, it appeared, no responsibility for that conduct. He didn't address at all the issues that we also discovered when he applied about his past license with the Savings and Mortgage Lending Department. Yes, on his new type of license, this national mortgage license, he had no complaint. But again, it's a new application. He has to tell us about, prior to that license, the two disciplines that they had to take at the Savings and Mortgage Lending Department. In addition to that, we actually had at that hearing the listing agent from that previous transaction come and testify. We had the investigator, she's still with us now, also testify that she had asked him for this information and he didn't provide it until actually he was already revoked by this commission 2 years ago. Then he provided the information to us, which I had, in addition to our investigator, sent a copy to him earlier that spring of 2012. So for all of these reasons, we just don't, our division did not feel like he complied with his requirement of satisfying us as to his present honesty, integrity, and trustworthiness. If you have any further questions, I'm here to answer those.
Commissioner Westcott, Martinez, anybody?
She answered basically everything I had in there.
Any other commissioners have any additional questions for the respondent or for our legal services? Okay. At this time, I will entertain a motion whether or not to accept the proposal for decision from the administrative law judge. Do I have a motion?
Madam Chairman, I move that we accept the recommendation of the administrative law judge in this matter.
I have a motion. Do we have a second?
Second.
Second from Commissioner Arriaga. Okay. All in favor, say aye.
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 Any opposed? Madam Chair, I'll hand the gavel back down.
Good job, Commissioner Turner. We'll move to agenda item 12, discussion and possible action to authorize settlement under recovery fund actions. Ms. Lewis.
Okay, just so you know, no action will be taken today on agenda items 12A and 12E. So the first agenda item up is Recovery Fund 14-013, Jonathan Schultz versus Heart of Texas Real Estate, AKA Team Loopy LLC.
Commissioner Justice.
Madam Chairman, I move that we pay actual damages, related to 14-013. I move that we pay actual damage of $4,660 and attorney fees in the amount of $5,340.
Got out of order.
For cost and interest.
I'm sorry. Including interest, court costs, and any reasonable attorney fees.
I think we got that. Is there a second?
Second.
All in favor, say aye.
Aye.
Opposed, no. Motion carries.
The next case up for consideration is Recovery Fund 14-014, Daphne Chess versus Team Lupe, L&L and LLC et al.
Okay, Commissioner Arriaga.
Madam Chair, in reference to 14-014, I recommend that we authorize payment of actual expenses of $5,127.07 plus interest, court costs, and reasonable attorney fees.
A motion to have second?
Second.
All in favor, say aye.
Aye.
Opposed, no. Motion carries.
The last case for consideration is Recovery Fund 14-015, Willie Keeler versus Susan Quiones.
Commissioner Alley.
Madam Chairman, I recommend the authorization of payment of actual damages of $4,150 plus interest and court costs.
Motion to have a second?
Second.
All in favor, say aye.
Aye.
And opposed, no. Motion carries. And E, we are taking no action on. Is that correct?
That's correct.
Just like to call attention to everyone in the room that these are rules being proposed for possible adoption. Adoption means it's going to happen if it passes. And for anyone who has requested the opportunity to speak on any one of these agenda items, you will be given 3 minutes. We will be taking time. I will call time on you. So for those of you presenting, Ms. Lewis, you have a little more than 3 minutes, but if you want to speak, it would be 3 minutes. So I would call agenda item 13 for
This is discussion and possible action to adopt amendments to 22 TAC Chapter 533.3, filing a notice, 533.4, failure to answer, failure to attend a hearing in default, 533.9, computation of time. These proposed amendments were published in the May 16th issue of the Texas Register, and no comments were received on the amendments as proposed. Staff would recommend that you adopt the rules as published.
I have no one who wishes to speak on these items and call on Commissioner Hensley for the motion.
Okay, Madam Chair, I so move that the staff is authorized on behalf of this commission to submit for adoption amendments to 22 TAC 533.3, filing a notice, 533.4, failure to answer, failure to attend hearing in default, and the new 533.9, computation of time without changes to the text as previously published in the Texas Register, except for any technical or non-substantive changes required for adoption.
I have a motion. Do I have a second?
Second.
All in favor, say aye.
Aye.
And opposed, no. Motion carries. Agenda item 14.
This is discussion and possible action to adopt amendments to 22 TAC Section 535.146, failure to properly account for money commingling. The proposed amendments to a new Section 535.146 were published in the May 16, 2014 issue of the Texas Register. The amendments were made following a comprehensive rule review for this chapter to better reflect TREC procedures and to simplify and clarify. The amendments created in this new rule, now called Maintaining Trust Money, combines and replaces the current Section 535.146 as well as Sections 535.159 and 535.160. No comments were received on these amendments, and staff recommends adopting the rule as published.
And I've received no request for comments. And Commissioner Justice, do you have a motion?
Madam Chairman, I move that staff is authorized on behalf of this commission to submit for adoption new 22 TAC 535.146, failure to properly account for money commingling, without changes to the text as previously published in the Texas Register, except for any technical or non-substantive changes required for adoption, and to repeal.
A motion is, and I have a second. All in favor, say aye.
Aye.
And opposed, no. Motion carries. Agenda item 15.
This is to the corresponding section to what we just adopted, and it would be to repeal those three sections, 535.146, 535.159, and 535.160, which are now replaced by the rule that you just adopted. No comments were received on the repeals.
I have no one wishing to speak on this subject matter. Commissioner Westcott, you have a motion?
Yes, Madam Chairman. I move that staff is authorized on behalf of this commission to repeal TAC 22, Section 535.146, failure to properly account for money commingling, Section 535 1.59, failing to properly deposit escrow monies in Section 535.160, failing to properly disperse escrow money as previously published in the Texas Register, except for any technical or non-substantive changes required for the repeal.
Motion to have a second?
Second.
All in favor say aye.
Aye.
Opposed, no. Motion carries. Agenda item 16.
Discussion and possible action to adopt amendments to 22 TAC Chapter 541, Rule 541.1 Criminal Offense Guidelines, 541.2 Criminal History Evaluation Letters. The proposed amendments were published in the May 16, 2014 issue of the Texas Register, and no comments were received on the amendments as proposed. Staff recommends adoption of the rules as published.
I have no one wishing to speak on this issue. Commissioner Martinez.
Yes, Madam Chairman, I'd like to move that staff is authorized on behalf of this commission to submit for adoption amendments to 22 TAC 541.1 Criminal Offense Guidelines and 541.2 Criminal History Evaluation Letters without changes to the text as previously published in the Texas Register, except for any technical or non-substantive changes required for adoption.
Motion and a second. All in favor say aye.
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 And opposed, no. Motion carries. Agenda item 17.
This is discussion and possible action to adopt amendments to 22 TAC Chapter 537 for Section 535.47 regarding the addendum for property subject to mandatory membership in an owner's association, and 535.51 Standard Contract Form TREC 441 Addendum for reservation of oil and gas and other minerals. Both of these were published in the May 16, 2014 issue of the Texas Register and went before the Broker-Lawyer Committee at their meeting in July. One comment in favor of the amendment for the addendum for property subject to mandatory membership in an owners association was received, and it was in favor of the change. No other comments were received, and staff would recommend adoption of that rule and form by reference. As to the addendum for reservation of oil and gas and other minerals, several comments were received, and the Broker-Lawyer Committee reconsidered that form and, in fact, relied heavily on a form that was proposed by the Texas Association of Realtors, who formed a committee with oil and gas attorneys and other brokers, and the Broker-Lawyer Committee recommended at this point to withdraw this particular proposal, and will be reproposing the rule and the attendant form later on the agenda.
I do have one person here who has registered a note that they're in favor of the withdrawal of the oil and gas form, and that's Rick Doak, who's at Farm and Ranch Broker, and a Ezra Johnson who wishes to speak on this agenda item. Mr. Johnson, you have 3 minutes.
You want him to speak now or later?
Say what?
You want him to speak now or later? We're good.
We're good.
Excuse me. Thank you, Madam Chairman. My name is Ezra Johnson. I'm with the law firm of Wolf, Fitzsimmons, Jewett, and Burton. I was one of the members of the committee that was put together by the Texas Association of Realtors to repurpose the form as originally proposed and resubmit it to the Broker-Lawyer Committee for their reconsideration. I don't have anything to add to what was previously stated prior to my rising to speak, but I am here to answer any questions that you might have. I was the primary drafter of the changes to that form and would continue to urge that it be the reconsidered form be reproposed for public comment.
Thank you. Mr. Johnson, would you be here when we get to 19 in case there are questions about the new form?
I will be.
Thank you. Thanks for your service. So I would look to Mr. Commissioner Turner for the motion.
Thank you, Madam Chair. I move that the staff is authorized on behalf of this commission to submit for adoption amendments to 22 Texas Administrative Code Section 537.43 Standard Contract Form TREC number 36-7 Addendum for property subject to mandatory membership in an owners association, and the contract form adopted by reference as previously published in the Texas Register, except for any technical or non-substantive changes required for adoption, and withdraw the proposal for amendments to Section 537.51, Standard Contract Form, TREC number 44-1, Addendum for Reservation of Oil and Gas and Other Minerals.
A motion to have a second. All in favor say aye. All opposed, no. Motion carries. Agenda item 18.
Okay, we are now moving on to rules that are being proposed for publication and public comment.
Thank you for reminding us.
So what we're talking about in agenda item 18 is a rather large proposal. It resulted from a lot of work by staff and 2 committees, reorganizing, clarifying, and making some changes, which are outlined in your materials, and I'll go through those, to Chapter 535 as part of our quadrennial rule review. I would like to particularly commend our ELS staff, who put a lot of time working with myself and Tony Slagle regarding the processes and clarifying terms. And in particular, I want to basically give a round of applause to Tony Slagle, who is an absolute master at taking large paragraphs of information from various places and putting them down in a very cogent, clarified manner that helps with understanding and readability. So.
Let the record note, I think it's the first time cogent has been used in a commission hearing.
And we're trying to get rid of the legalese. What am I thinking? Okay, so Chapter 35, most of the rules are the same, except we tried to get rid of a lot of redundant and unused provisions and restructure the rules in whole or in part to be in a more logical order. Rules that are no longer needed or that have been totally rewritten are also being proposed for repeal in this section. The most dramatic reorganizations were made to the licensing and education rules, which over the years have gotten to be a bit of a patchwork. The proposed amendments capitalize the term commission and replace the term licensee with license holder throughout the chapter, and the terms promptly and reasonable time were removed from the definitions and were replaced throughout the rule with the actual time frames that apply to each section. Easier for people to understand and find what requirements they have. I'm not going to read every single subsection that I pointed out in your materials about what changed. I will highlight a few of them for you. Under subsection B, there was a change to section 535.4 to hold a person conducting brokerage business from another state through mail, email, internet, or other medium under the jurisdiction of the Act if that property is located in Texas. Also, a section on mailing address and other contact information, a new section 535.21 was created, and that's simply moving that section from another section in the rule. Also, under the disclosure section, and I don't have that number in front of me, a provision was added where you have to note that a broker's opinion of value, you have to give a disclosure if you're not doing it as an appraisal, and that was expanded to include not just a CMA or a BPO, but any opinion of value, and that is to accommodate the AVM issue that we're seeing out there, that where automatic valuation models are being used to give opinion of values, and just to make sure that disclosure is on there for the consumer as well.
So it becomes a licensee's responsibility, just to be clear.
Correct.
That if their name shows up on an AVM produced by some third-party vendor, that this disclosure has to be there.
Right.
Licensee is responsible.
So that the consumer understands that it is not an
Just
actual
making sure.
appraisal.
Thank you.
Yeah. In subchapter E, I just want to highlight that is where the broker responsibility working group in section 535.56 set out some revisions to the experience points that were mentioned in the report given earlier today. I'm going to skip my comments on subchapter F and G for the moment. I will come back to them. I just want to point out a few other things on the rest of the rules. Subchapter I was restructured and clarified regarding license renewal. Again, mostly just to make it easier to understand and follow for all our license holders. One change in the renewal process is that the fee that is required, and the fee is staying the same, that is required to defer completion of continuing education for up to an additional 60 days will now, if this rule goes through the process and is adopted, will then be due at the time of the filing of the renewal application, not after the fact. Okay, so at this point, I think I will go ahead and jump back to F and G, and I do want to clarify that these rules at this time are being proposed. The subchapter F rules deal with pre-licensure education programs, which are now going to be called qualifying courses, and subchapter G deals with continuing education programs, which are going to be called continuing education courses. These rules were vetted quite thoroughly at ESAC's meetings and also by the inspector committee as they relate to inspector courses. And with the exception of what's being recommended on correspondence courses, I think uniformly were supported. So let me talk for a minute about correspondence courses. Correspondence courses under this proposal will not be allowed as a delivery method for TREC pre-licensure courses or TREC continuing education courses after December 31st, 2015, due to a lack of any meaningful standard or oversight of these courses delivered by this method. Please note, I'll say it one more time, that ESAC is not recommending the elimination of all online courses. Online courses may still be offered if they qualify as alternative delivery. Under the proposal, alternative delivery courses must be certified by a distance learning certification center acceptable to TREC. This certification center reviews the course and certifies the quality of the design and delivery, including that the course is designed for mastery-based learning, verification that the average time it takes a student to complete the course is the number of hours assigned for credit for the course, that the instructor is certified as a distant education instructor, and a procedure is in place to authenticate that the person registered to take the course is the person taking the course in final exam. The Commission rules currently provide for alternative delivery, and there are courses approved under this method today. I would also like to note that the Inspector Advisory Committee acknowledges the existence of problems with correspondence courses, but is recommending that correspondence courses not be eliminated currently for inspector courses so that the Inspector Advisory Committee can have more time to study available alternatives for inspector courses, given the different nature of inspector courses and the dramatically lower pool of students and instructors. So in this proposal, that restriction or the provision that goes into effect on December 31st, 2015 would apply currently only to real estate education courses, not inspector courses. Also, the proposal has a provision that will require by January 1st of 2016 8 hours of adult education training for instructors for every 5 years for pre-licensure and non-elective continuing education instructors. Does not apply at this time to continuing education instructors. So the only other part that I would point out is there is now a separate section was developed to deal with accredited college and universities. Since these entities are exempt from approval or accreditation as an educational program, but the commission still has the authority and ability to decide whether any courses comply with the requirements for credit. So that is my shortened summary from what is in your materials. Does anybody have any questions of me at this time? I know there are people who want to comment on these rules.
Any commissioners have any questions at this moment? Okay, thanks, Ms. Lewis. Our first speaker, 3 minutes, Rita Santa Maria. Are you timing it? I guess we won't start till she starts talking. We won't start till you start talking.
Thank you.
Better not be ticking now.
I have choices. General Counsel.
I'm Rita Santa Maria, the owner of Champion School of Real Estate. Chairperson Wu Cash, members of the commission, Mr. Olmixon, and other members of the staff. My concern is the recommendation of the advisory committee to eliminate correspondence courses. I believe it is not in the best interest of the consumer. In particular, it harms our service members and veterans retooling for civilian life. It harms my CAA, the program for military spouses of our service members, in the lower service grades seeking career opportunities through education and training. It harms those Texans living in small communities without access to a brick-and-mortar facility from obtaining their real estate license. And our veterans have told us they often cannot use online computer delivery as their vehicle for course study, as it compromises their security position. So they are thankful for correspondence home study. If the commission approves the advisory committee recommendation, it will not only eliminate home study correspondence, but a vast majority of online courses which use the correspondence model to provide their courses. That model is printing off a PDF of the textbook and homework and taking an online exam, eliminating the requirement of locating an exam proctor. To date, there are very few online IDEC-approved courses offered. Champions is one of few proprietary schools using resources to move forward to get IDEC and ARELA approved. It is simply too labor-intensive and costly for the small real estate school provider to undertake that rigorous and timely process, and colleges and universities have no need for the endorsement of IDEC and ARELA. Further, the advisory committee recommendation will work to dilute the regulatory strength of TREC. Colleges and universities will be the only providers left to offer correspondence courses, and TREC has no regulatory authority over colleges and universities in Texas. On the other hand, if the commission would eliminate the requirement for a provider to be in association with a college or university to offer correspondence courses, the exact opposite would occur. TREC would find more muscle in their regulatory authority by being able to control the prerequisites for offering correspondence courses. Validation, authentication concerns can be addressed and resolved by incorporating the same procedures we use for NMLS. Another unintended consequence of eliminating correspondence courses is sponsoring brokers are going to find fewer candidates for their offices, that it would be more time-intensive to complete the requirement for a person changing careers. That feeds directly into lesser application and renewal fees for TREC and the Real Estate Research Center. The email I wrote, dated April 7, 2014, to Chairperson Mukash and Mr. Olmixon, along with the supporting statistics, are attached in your hands. I provided, it compares in-class versus correspondence pass rates. The data was taken straight off the TREC website. In other words, the advisory committee had access to the same information just as the general public does. For reasons outlined in my email, these statistics are representative of 80% of the providers. Bottom line, for the period March 2009 through February 2014, the statistics show the passing ratio for correspondence is 66.87% compared to 61.16% for those taking their courses in the classroom. This data mirrors what IDAC had to say on their distance learning website as of this week. As a substantial portion of existing research suggests, there is no significant difference between the outcomes found in the traditional classroom versus the distance learning environment. Rule 535.75 of the Commission directs the ESAC with reviewing the core course content and curriculum standards and instructor certification requirements. The rule is conspicuously silent on the committee's authority regarding delivery methods. I believe this proclamation to do away with correspondence as a delivery vehicle for approved courses reaches beyond what the rules of the Commission intended and adopted. I am here today asking the TREC commissioners at a minimum to leave correspondence as it is currently offered and defined in TREC Rule 535.62, 1 and 2. More enthusiastically, I would ask the members to eliminate the requirement for providers to be in association with a college or university in order to offer correspondence courses. Thank you.
Thank you. You can breathe now. Oh, where's a question?
Sorry. First off, thank you for the documents you've provided to us, and thank you for your comments. But Ms. Santa Maria, I guess one of the main questions I have is how many correspondence students do you run on an annual basis?
A lot. In association with Lone Star College. And by a lot, I can say easily 20,000 in association with Lone Star College.
And those 20,000 are running through the correspondence
Yes.
solely, holistically?
Yes. They're what we call fast track, where you have half of the time of the 30 hours in the classroom with an instructor. The other half is doing correspondence at home, homework. But you're getting 50% of classroom time with a teacher.
Yeah, so I guess the main, as you were going through your presentation, one of the things that you mentioned was the obvious the statement regarding the number of licensees that we're having, and I would say that from my aspect and probably the view of the rest of the commissioners, we're more focused on the quality than the quantity of the number of people that are getting licenses in the state of Texas. But your information is well put, and thank you for your presentation.
Thank you.
Oh, wait, Commissioner Arriaga.
What % of your business and maybe other schools are done online versus regular coursework?
About 55% of my business is the hybrid of half being correspondence at home study and the other half in the classroom with the teacher. 55% is that combination. 45% is online. But online is exactly as I mentioned, where it's also correspondence, where you're PDFing, printing off the textbook, and doing homework, and then taking an online exam. It does have timed questions, authentication questions as you go through the online program. And total per year, our numbers that we're putting through are more like about 50,000.
Any other questions for Ms. Santa Maria? Yes, sir. Commissioner Turner.
Ms. Santa Maria, thank you, first of all, for your time and your participation. We appreciate that sort of thing from constituents, certainly. I would just like to know, it's a very general question, but I appreciate what you had to say with regard to the availability of online classroom setups for our folks in the military. But with regard to everyone else, those that are not stationed abroad with the military, why wouldn't online services be sufficient as a replacement for other forms of distance learning that these rules would get rid of?
Because the direction that we have here in the change of the rule is that it has to be IDEC approved. And IDEC approved with a very fine curriculum developer and 7 people behind him to get one Principles 2 course approved. It took 8 months for one course to get IDEC approved. Once it was submitted in all of the timed format with interactive play, with video, once it was submitted, it was approved the first time. But it took 8 months for one course to get IDEC approved, and that is not atypical.
Sorry, one more. Is it your position that applicants or current license holders that are doing NCE receive the same level of education via correspondence courses that they do via in-person classroom instruction?
I absolutely do. And I've been in business 31 years, and I started out with straight 30-hour courses. And yet, the data that I gave you is to show when you take the passing rate off of the TREC website, the correspondence student grade percentage is not even 1 point different. In fact, it's 1 point higher on correspondence versus traditional 30-hour, as Lone Star College says, butt in the seat.
Thank you.
Any other questions? Commissioner Alley?
You had mentioned you all have a collaboration with Star College, is that?
Lone Star.
Lone Star. And what is the relationship? Do they certify that that class that you are providing to the correspondence students is certified through that entity, or what is that?
Yes, I sit down with the Dean of Continuing Education twice a year, in the spring and in the fall. They look at the Champion School of Real Estate courses, the course itself, the outlines, the books, the materials, the homework, the final exam, and they review it. They keep it in their file. We discuss maybe any situation where they ask questions about some of the questions, and we change them out. They know what our certificates look like. I certainly know all the members of my committee. And so it is a formal review. They are not given academic credit hours because the program is too short in time period, 180 hours, but actually they're working with our company right now to move some of our courses into their business school so that some could be given academic credit.
So this is kind of under the auspices of adult education?
It is totally adult education.
Okay.
One more question.
Commissioner Arriaga can go first.
Okay.
I guess this is to Mr. Olmixon. Do you know Lone Star Education Company that Ms. Antonio
Lone
is
Star
talking about?
College.
Only by their association with Champion School. Otherwise, I mean, I've driven by it.
Okay, well, because I see in the internet, I get requests from a whole bunch of people offering online education, and some are not from Texas. But if I was going to do it, the only reason I do it is because of the dollar amounts. It's very, very cheap. I can get it done for less than $25. I don't know whether it's going to be good or not, and I would, of course, not take it, but some people are. And I question that if there's some people doing online education, whether we are really overseeing those.
So let me make sure I understand your concern. Is it that there are online courses available that are not reviewed by us?
That would be the question. Are there?
No, sir.
So everything that's done online, received by a person taking real estate courses in Texas, are all reviewed by TREC.
Yes. Currently, either as the through a principal provider, or there's also a secondary provider network, and then there is there's the online marketing business model that essentially attracts students through a marketing model to take someone else's class. That is an approved class. But I think I think what you're, at least I believe that what you're getting at is that, which is the root of this, the root of the concern, and why this issue first came up, is that you can go and take a class, and this is principally in the area of continuing education, not the qualifying education. But you can go online, pay your $40, and get 15 hours and complete it in 15 minutes, that kind of thing.
That's correct.
Those are clearly correspondence courses under the classic definition of a correspondence course.
Thank you.
Okay, one down here and one down here. So
Mrs. Santa Maria, you made a very eloquent case for, why correspondence courses work, and I thank you for that. I guess the thing that perplexes me, with it being such a positive method and being such a big part of what your entity is doing, why even offer the hybrid? Why aren't you offering classes full correspondence? Or wouldn't that increase the numbers?
If I have the opportunity to tell you why we even went to hybrid, is because online came into the picture, and our students were leaving the classroom in 2004 and going straight to at-home online study. And I personally, being an educator by education from Florida State University, I believe that they need to be back in the classroom. So as I saw them leaving the classroom to be on their computer and at home in 2004, that's when I thought, let me try a hybrid where they are able to get their license in half the time, but they still get an instructor for 15 hours out of a 30-hour course. And I can show you the chart and graph that I've shown my instructors over these years, where it showed that over time, those total 100% at-home students started coming back into the classroom. Because yes, it wasn't 180 hours of seat time, it was 90 hours of seat time. And I felt like they got more out of it by having at least a person there for half the time. Doing away with correspondence, I think they will, frankly, it will be just an exodus to online, out of the classroom.
Got it.
Commissioner Turner.
Ms. Santamaria, do you acknowledge any shortcomings with regard to correspondence education versus other delivery options?
Yes, because as Mr. Arriaga said, if it is not documented as to how much time they're spending on a course, then indeed there are those providers, particularly out-of-state providers, and all they offer is a very cheap course and a very fast course. It is really simple and something we have already in place with all of our online hybrid correspondence courses, where it's timed. I know how much time you spend on a question. I know how much time you spend on a page. And if you wanted to come and say, okay, I'm going to take this course, and you tell me how long did it take that student to do that entire process, at Champion School of Real Estate today, you can go down the street and do that. And if that were required of all online providers, then you would absolutely know how much time is being spent on a course, and it's not difficult to do that.
Any other questions? Thank you, Ms. Sarah. Appreciate it, Rita. Lynn Morgan. I presume you were on this subject matter even though you gave me the rule number. I'm just guessing. Okay.
Hi. Lynn Morgan, owner of the Austin Institute of Real Estate, and I thank you for your time. I'll try and be very brief myself. I would like to direct you, if I could, to the supplement that was submitted for this agenda items 18F and 18G, submitted by Rick Elbers. You have that in your materials?
Rick Albers sent us a letter. Let me see if I can find it.
It starts. Yeah, it's a blank, kind of a blank page at the top, supplement to agenda item 18F.
Oh, it's in the packet, not his letter.
Supplement.
Okay. Okay.
Everyone have it?
I'll look at Doug's.
Go ahead.
Okay.
I read his letter.
I just wanted to point out a few things, because I think that this is kind of the essence of the ESAC committee has taken and around correspondence courses, and I am in agreement with Rita from Champions that I think that we should absolutely continue to offer correspondence courses. And I'm just going to refer you to several spots in Rick Elber's memorandum. Number one, about the quality of instructors and instruction, in paragraph 1. Where it's the second to the last sentence, where it says the use of correspondence courses completely discounts the use of those instructors. And when I read that, I said, you know what? Who is he trying to protect? Is he trying to protect the consumer, or is he trying to protect instructors? And it's not really about protecting instructors and driving people back into the classroom. So I totally have an issue with that statement. And number 2, about compliance with the Texas Real Estate License Act, where he says about the correspondence courses are commonly completed in far less time than the number of credit hours. I would like to ask Mr. Elbers where he does get his facts, because that is strictly his opinion. He's certainly, welcome to it, but that indeed is, in my opinion and in my experience, is not the case. We have people who are constantly calling us, taking their MCE courses, saying that our questions are so hard and that the course is so hard that they cannot complete the 3-hour legal or ethics in 3 hours. So I don't know, he's obviously had another experience with that, but we have the experience of people saying that they don't complete them, and who's to say that they don't complete them in less than or more than, the 3 hours or 30 hours of course time. Under number 3, about the correspondence courses are antiquated, I think that very bottom line where it says there's no need to settle for that inferior quality today, and again, Mr. Elbers is certainly welcome to his opinion, but that is indeed not my experience. And the ironic thing, folks, if I could just address this, is that I think it's very ironic that the ESAC committee has spent almost a year developing curriculum, all this curriculum outlines, going very specific about we want 10 minutes of this covered and 15 minutes of that covered, and you folks approving, this entire curriculum. We, as providers, are completely rewriting all of our materials and getting it in compliance and getting it approved. It is everything that everybody wants, that this whole committee has said, this is what we want them to know. And if they can take that, whether it's in a self-study, it may take them more than 30 hours. Some fast readers may do it in a little less. But if this is the material, and if this is the information that this committee and that the commission wants them to know, what is wrong with them doing a self-study and passing the exam? If they pass the exam, there's another fail-safe. There's the state exam. If they're, quote, cheating and not spending 30 hours, particularly on this course, maybe they spend 25, maybe they spend 35. But if they spend time and know the material and can pass the exam, that in our line of work is they're competent, and they still have to pass the state exam. And if they can't pass this course, they're not going to pass the state exam. So that's a huge point with me about him saying that these are inferior quality. The other very last line where it says distance learning can be provided to all areas of the state through other methods with superior quality, I think that, again, that's just opinion. I feel that that's not even true. As Rita pointed out, there are people in outlying areas that they don't have the, the capability of getting online and doing an online course. So I think correspondence has been, very, kind of underrated. In the next paragraph, Mr. Elbers says about he completed a 3-hour MCE ethics course in less than 30 minutes. And I thought, well, hello, I would certainly hope that he would. He is a real estate attorney. He specializes in commercial, land and tenant representation. This is on his website. On mechanics liens, real estate curative matters, brokerage issues, I would hope that he would be able to pass a 3-hour ethics course written, and it's TREC's materials. It's not our materials, it's what TREC has written. TREC has written a course that is supposedly a 3-hour course. So if he can pass it in 30 minutes, well, good for him. I mean, he should know this subject pretty well. I'm sorry, just a couple of other comments.
Quickly.
Okay.
Quickly.
Okay. In the paragraph just above the last paragraph, second to the last paragraph, where he continues to talk about this being a substandard delivery system and that it doesn't protect the consumers and it merely allows the licensee and education providers to circumvent the rules, thus making them more dangerous to the public, interest, and consumers. I think that this is very inflammatory, and I think it's really insulting to providers of real estate education. We have all made a huge effort to write really good materials, provide a good agent when they get out of the courses, and there's no facts. The bottom line of all of this is there are no facts, or there are no statistics except Rita's that show that the pass rate is higher for these for people taking correspondence courses. There have been no facts presented at all that this produces an inferior agent, that there are more complaints filed against them, that they have, that they're less ethical than a person who took classroom education. There's been nothing in the Education Committee that has presented any facts to that. So thank you for listening.
Thank you. Any questions for Ms. Morgan?
Giving me the time.
Yes, ma'am.
Commissioner Arriaga.
What percent of your business is online?
Online, about 20%. Online being the strictly online or correspondence.
Correspondence, both.
Correspondence total about 80%.
80?
80.
Do you have a question, Mr. Westcott?
No, I mean, I just think anybody who's going to speak in support of the ESAC standards, I would want them to address what she said, that there are no facts that say correspondence courses create an inferior license holder.
Anybody else?
Yep. I had one of the same question that I asked Ms. Santa Maria. Do you?
I'm Ms. Morgan.
I know. I'm saying I'm going to ask you one of the same questions I asked her.
Please.
Do you acknowledge any shortcomings in correspondence courses versus alternative delivery methods?
Yes. I think I have, there are a couple of solutions, I think, to that. And I think one is that I think that there's been a lot of concern about colleges and universities, not being as involved with the proprietary schools. And there's kind of like, just their name is on, is on these certificates. That's been one concern, it seems, from the committee. And I think that a huge solution to that would be to take the newly approved materials that we've gotten approved through the Real Estate Commission, and have the college or university sign an agreement that they would agree before they become associated and offer these courses, that they would agree to say that they would use those materials. And if they agree to use those materials and they're approved by TREC, I think TREC would be fine with it. And the other thing is, I think we can control the time of these courses, if that is an issue, by making it harder, making these courses, making the tests harder. And I think that that would be a great, not job, I don't want to say job, but a great charge to the committee, the Education Committee, to create banks of questions. If they want to make the course harder, make the questions harder. Make them harder for them to answer so that you know that they are really, indeed, reading the material. And if the materials are approved through TREC as a 30-hour course, then everybody should be happy. So I do see that there are shortcomings, that I think sometimes the test questions are somewhat leading and that type of thing. But
you mean the test questions at the end of a class?
At the end of a class, the final exam.
Okay. Thank you. Any other questions for Ms. Morgan?
Could I answer one other question that you asked Ms. Santa Maria about the why correspondence courses are a good thing? What I found is people still like to have the textbook. They like to have it. They like to have it in their hand. They like to mark it up. They like to refer back to it. And that's a big thing with online courses, that you only have the course for so long and then the material's gone. And I know that material changes and all of that, but it's still nice for those students, I think, to have a hard copy of a text that they can use. And they really like that.
Thank you. Thank you.
Okay, thanks.
I have had a request, not on an official form, that somebody wants to speak. I need it on an official form, and you know who I'm talking about if you're in this room, and sent me a note. I need it on the paper. Okay, Donna Harbuck, you did fill out a paper. I'm not sure I'm going to let you turn your time over, but we will. Thank you. You've chosen not to speak. Stan Harbuck. Waldman. Deb Waldman.
Thank you all for the great work that you do here. I can sense from your questions and from your past conscientiousness that you've shown in other meetings as well. You really want to get to the bottom of this, as you do with many other issues that you have to deal with, and I appreciate that and the great volunteer work that all of you do too. I know this is a great deal of effort and time on your part. Except for asking the Commission today to allow the Inspector Committee, the Inspector Advisory Committee, to review subchapters F, G, and R, which if I was in both the ESAC meetings and the Inspector Advisory Committee meetings. If you wanted my opinion, I would suggest to you that the Inspector Advisory Committee did not have as much time to review those subchapters as the ESAC did, and did not review them in as much detail. And I would just ask you to propose that you wait on that, if you would be willing to, and make that a future proposed rule after the scheduled meetings that the Inspector Advisory Committee has already scheduled has a chance to review those. But other than that, in a way, we really don't have a dog in this hunt. We provide only home inspector courses, and those have been exempted out of some of the requirements you've been talking about today. But we do still feel an obligation to try to represent those that we serve on the home inspector side, because we know some of those people also want to be real estate agents as well. The groups that I'm talking about here are the poor, those that have English as a second language problem, also single parents. We get calls from these people from time to time for our home inspector courses. We believe they also are interested in real estate sales courses as well. You know, I actually do some volunteer work at the high school level in my area, where I have a lot of contact with poor families that are their children are in high school. And there are a lot of things that we're not discussing here in any of the meetings that I have seen so far about the poor and their opportunities for business as well. In particular, internet access. Even in Texas, the statistics suggest that about 30% of the families, households, I should say, in Texas do not have internet access. That's a very significant. I would suggest to you that the bulk of those are those in the low-income bracket as well, once again reducing their opportunities. I'll repeat sort of what, well, I won't repeat it, just to glance over what Rita said about the 80%, close to 80% of those that are real estate sales trainees now are going through some sort of correspondence through public universities. And of those, the pass rate is at least slightly higher for real estate sales trainees. It is actually significantly higher in the home inspector arena. This is additional proof that correspondence courses taught through public universities are serving their purpose and serving them well. I guess I should say, you know, if it ain't broke, don't fix it. Continue to allow the poor, ESL, single-parent families, and a number of other groups that are in these categories that I often work with myself on a volunteer basis, and don't take away these opportunities from them by disbanding correspondence courses, even in that area that we don't even teach in right now, real estate sales. You know, these are, we get calls from these people, they want to have their own small business too. You know, the low income, it doesn't mean that they should be precluded. And what we're doing by advancing these rules, how many times have you walked around and you see somebody with their earplugs in and they've got every single gadget that you can think of, and they're so productive? I understand that completely. Those devices, the wireless programs and so forth that go along with those, they're just not available to the poor. And I can give you specific examples of families that I've helped where that's the case. Many of them are afraid to admit that they can't afford to get wireless or internet service for their home, and would rather say that it was broken right now, you know. So anyway, thank you so much for your work. If you have any questions, I'd be happy to answer.
Any questions for Mr. Harbuck? Thank you.
Thank you.
Scott Hilton.
So I'm the one supporting ESAC. I haven't been killed yet by any of the other schools here, thank God.
That's because you just came out.
I am an online school provider, do MC courses, sell SAE courses, pre-license. I'm also a real estate broker. I've already sent you a previous letter that you probably read. I think it was a couple pages. Yep. I'll keep it short and simple. It is broken. It does need fixing. If I can take a course, get it mailed to me or download, let's say with the 15-hour MCE course, and finish it in 10 minutes, there is a problem with that. The problem is not about being tested. The problem is not about even being properly tested. It's about being properly trained. You need to spend the time, whether it's in an alternative delivery method or a classroom setting, and get those stories from the other people in the classroom, from the instructor, from the interaction that you get, which is what you get in an alternative setting, that you can't get from a correspondence setting. Correspondence that I've dealt with is you get the book. Most students say, I want correspondence because I can get the book. Where's the test? Take the test, I'm done. Okay, I'm going to admit something here. I took most of my broker's hours through correspondence, so please don't take them back away from me. And it took me maybe a week to finish them all. Okay? I learned so much as an instructor when I'm teaching to the students. And those stories, and it's called what we like to say the war stories. If you wouldn't believe what happened to me this time with this transaction, or when I was dealing with this borrower, or this buyer, or this seller, or this inspector, or this title company, all of those stories when you're teaching is what comes into play in a classroom setting. So what do we have? We have alternative delivery. In an alternative delivery course with a RALO approval, we're supposed to create that interaction. And we do that where the students can interact with other students, they can interact with the instructors, and I haven't seen that with any correspondence course. It may be out there, but I haven't seen it. So I'm here for questions, but I do support everything I've heard from ESAC, actually except one thing. The instructor certification. I believe you're doing that only for the non-elective, is that correct? The qualifying is your new word? Yes. Okay. I say do it for every one of them, because the non-qualifying courses, in my opinion, can be just as important. So I say do it for all of them.
Commissioner Westcott.
It was our second speaker, the lady who spoke after Mrs. Santa Maria. I'm sorry, I forgot your name.
Lynn Morgan.
Ms. Morgan. It was Ms. Morgan's contention that there are no facts supporting the notion that correspondence courses produce inferior agents. Do you dispute that, and do you have any facts that would show that?
I'm factual based, and since you're asking for facts, I don't have those facts. What I can tell you is if I sat through a course where I sat for 15 hours and listened and did whatever it might be, some sort of interaction, and got stories from that instructor about a certain topic, I guarantee you I would learn something. Whereas if I just took a 15-hour course and said, I am smart, which guess what? I am smart, and I probably could pass any test that I took. I've been in business since I got licensed in 1986. I could probably take any course, any test that anyone in here provided me and pass it without even looking at any of their material. Does that mean that I could not learn something from them? I don't think so. I think I could learn something. And guess what? There's something that happens on a monthly basis, even weekly basis sometimes with laws, and things do change. Anyone that thinks they know everything, they don't. So it is my assertion that even though I don't have facts to show you, I believe that people do learn just by simply going through the material, not just because they can pass a test.
Commissioner Martinez?
Can you dive into the some of your students and where they're taking your classes from? You know, we talked earlier, it was very prudently mentioned that some of our military folks, they're limited to what they can or can't do or have access to, and maybe somebody in a rural community. Somebody mentioned somebody due to financial reasons, lack of access to internet, things like that. Can you tell us how everybody else has told us how their business breaks down? Can you do the same thing so we can understand who is and who's not using online?
I was afraid you were going to ask that question, and I don't have exact numbers, but what I can tell you is we are 100% online. We are an online MCE provider. We are not a core provider. We do sell the core classes through other schools. I will tell you that probably 90% of my business is alternative delivery versus the other 10 to 20, maybe a little bit more, is correspondence, only because the students want it and they call in and say, we want the quickest and the easiest.
And I appreciate that, and I'm looking more for how many military folks are taking the online courses? How many folks in a rural community?
I get a call at least once a year asking for a military discount. I am a veteran, and guess what? I lost my license back in, I want to say, 89 or 90. It might have been one of those years for guess what? I was overseas, and guess what I couldn't do? Take my continuing education, and guess what TREC told me? Tough. That's what they said at that time. Even if I had been able to take a correspondence course at that time, do you think that the 3 or 4 month mail delay of sending a correspondence back and forth would have even worked? I don't. So I don't know those answers to all those questions. There's always going to be a need or a problem with every single person. Welcome to life.
Questions?
The students have 2 years to complete it, is usually what TREC says. So they need to find a time and a period during those times.
Any other questions for Mr. Hilton? Thank you.
Thank you.
Diane McCoy, representing the Education Standards Advisory Committee. Okay, we won't start your time till you start talking either. No. They're telling me that I have to drop you to 2 minutes. I'm not doing that. I gave everybody else a little bit more than 3.
I'm Diane McCoy. I'm a member of the Education Advisory, Standards Advisory Committee. Commissioners, Madam Chairman, I'm here to make a few comments. Our report very clearly states the direction that we have suggested for our committee and on the lines of education. We were charged to look at the quality of education. And many good arguments have been posed, which I will address, and some questions I hope I'll be able to answer on behalf of the committee. I myself am on the committee as an educational appointee. I am TREC approved for legal, core, now qualified, broker responsibility and ethics, and I teach new agent training. So I'm in the classroom regularly, working with webinars and onlines, and I listen to the new students as they're making comments as well. Our committee discussed many of the things over the last year that we're looking at, and we are concentrating on sections F and G as it relates to correspondence courses, which is what I'm going to be addressing. The issue of quality education is what we were charged to study, and one of our main concerns is the mastering of the material, and that's what we focused on so much in our decisions. Questions have been raised about the rural, the military participant who is possibly going to be lesser addressed because of the correspondence, and our concern along those lines were this is going to be a practitioner who's going to be going out and servicing the consumer. We had 2 issues. We wanted fairness to the licensee, that if it was going to take a certain amount of time for one person, it should be for all, and also for the consumer. Is the consumer going to have someone who actually mastered the material? There are quality classroom courses, there are quality online courses, some of which that are combined with webinars. I think we all agree that the quality of education is there. We agree on the fact that education is important, all of us in this room. I think where we disagree is on how it is being presented and how we want to improve upon it. Attitude is a big part of what we and materials that we were reviewing. What our committee sat there and for months studied the materials. And the most recent meeting where we had to come up with a conclusion to propose to you today had to do with the materials and listening to the schools that were giving us their opinions on both sides of correspondence courses. And we were very impressed by the materials that we heard and also by the speakers who said it was time. This was not the first time that this committee or one like it has reviewed correspondence courses. It's been back almost a decade. And when we began to see that there were some instructors, some schools that were presenting material, and they were very proud to say, as in some of the material I just handed out, that it was not time-based, it was knowledge-based. If you could pass it in 15 minutes, as one of our speakers said just this morning, just a few minutes ago, good for him. Is it good for him? In TREC, in 2 places in Section 535, it clearly speaks to the fact that there should be an amount of time that devoted the time prescribed for each topic, and under advertising that there is full clock hours. So 15 hours for one person taking a course should be 15 hours for everyone. And if someone can pick up a class material on a Friday and take a test on a Sunday, and of course they haven't been studying that nonstop, but if they were able to complete a 3-hour course in 20 minutes, it's not good that they just know the information. And studying to the test, which we heard instructors and schools talk about, is not quality education. It's passing a test. And yes, passing a test is an important indication of being able to take that test, but what about the consumer? What about mastering the materials and really knowing what goes along with the rest of the material, be it a core qualifier course or be it a continuing education course? The ability to have more information provided over a controlled 3-hour online, including webinar, online course, or a classroom course. We know the quality of that material because it has been checked twice by IDECT and it's also been checked by TREC. And we know that the amount of time that a student is being asked for on online is going to be the time prescribed, the expectation of this commission, TREC. And also, we know on a classroom, because we have stringent rules for classroom attendance. So the guidelines that are online, the guidelines that are in the classroom are not there with the correspondence course. We don't see these people. We really don't know what they may or may not be doing. They may be taking a test in 15 minutes because they've had a license for 20 years. And as far as the individual who is in a rural area, our concern there are the tools. In this business, to give good consumer information, you need to be able to get online to the tax rolls. You need to be able to get online to, be it forms, be it MLS information, to find the properties that are out there to truly do a good job. If you can't get online to take a course, then you're probably not going to be able to get online to search for materials, properties that are available, and the tax information that backs them up to give full service to the consumer. So possibly it's not time for them to get into the real estate business if they cannot get online to take their courses.
I have questions for Ms. McCoy?
I do.
Yes.
So, in your experience, what sort of, I mean, everything that I've heard today says that there's no accountability to stop someone from just going to the end of the test and taking the test. Everybody, I don't, whether you're from online or whether you're from correspondence, everybody agrees you can do that. I had a speeding ticket one time, Madam Chairman. I know you're surprised about that.
I am.
And I thought that I would be smart and take a correspondence course for my defensive driving. So I ordered that time the videotapes. And the reason why I thought I was smart is I had a video player that would play
VHS?
3 or 4 words.
VHS?
VHS. And it would play 3 or 4 words at a time, so I figured I would fast forward through and get to the answers of the questions and write the questions down, thereby completing the test required by DPS so that I could go out there and drive. But you want to know what they did, Commissioner Westcott? In that test, they had their set 45 questions, but in that test, they had other things in there like, now stop and write down the number 3. And then you got down about question number 22, and it said, go back to question number 3 and multiply it by 5 and subtract 6 and write that down as question number 22. The point that I'm getting at, whether it's online because I am a very technically savvy individual, or whether it's correspondence from the VHS days, because I know sometimes that's necessary, if there's no accountability, what does it matter? To your point, what type of quality, and to go back to my point earlier, I don't care about the quantity, I care about the quality. And I want to know that these people know what they're doing. So, you know, if somebody can just answer the test, do we hold them to a higher pass rate? I mean, you could probably, you know, you should be able to get a 99 every time you take it.
Perhaps. Perhaps.
So should we hold you to a higher standard? So there seems to be a whole bunch of gray areas that are created because it seems like we're lacking accountability in the process. And again, everybody that's here for correspondence, I got no problem with correspondence. Everybody here online, I got no problem with that. But how do we make sure that people are learning what they're supposed to learn?
And I think that that's Commissioner Martinez, one of the committee's points. We know how we can control, if you will, the online, what's provided in the online and in the classroom. But it's totally out of anyone's hands once it's in the mail. What type of support does that person have? Yes, there's supposed to be instructors that are available to address them, but the face-to-face, the group efforts that you can take advantage of in a role-playing situation. I've heard from students in new agent training, just got their license. Where did you get your training from? And those that have said to me, I am so frustrated because I took it all through the mail and I wish I wouldn't have done it that way because there's so much I missed and they didn't realize it until they were sitting in a class with others.
And I'm going to be okay with correspondence, but I'm going to tell you, I'm going to make the statement that I'm going to be looking for us as a group to figure out how we put accountability into correspondence. That's all I'll say.
Okay, Commissioner Arriaga has a question.
Yeah, I do, and I was getting ready to honestly to make the motion to approve this recommendation, but I'm having second thoughts, Madam Chair, and the reason for that is that in protecting the public, I can go either way. I really can. My main problem is that online courses, I'm convinced, no proof, that people are cheating. And not only them going through, getting other persons to take the course for them. But I got no proof. In real estate, there's a science to real estate and an art to real estate. What we do here in Real Estate Commission is the science. But the complaints that we get from the public is not, he didn't tell them about the fiduciary relationship, he didn't tell them about the contract or my title policy. It's the art about relationships and confidence and the honesty, trustworthiness, and integrity that we cannot teach in online courses. There's more to it. So I'm not really convinced today, don't know whether we can take the step and make a recommendation today or whether we can wait. And if we do take the action today, can we change it later on?
This is an action, if we were to take it, that proposes this for comment, and it would be theoretically altered or adopted at our November meeting. So the action today is simply to move forward for posting for comment. Proposal. And I have another question from Commissioner Justice.
Actually, no, I don't have a question.
Comment.
But I want to say something. I've been sitting here and I've listened to each and every individual speak, and I appreciate very, very much they're taking their time to come and do it because I've heard lots of different things here. And I don't like to come from I don't just want to say what my opinion is about things. I want to listen and be open to the comments of others. You know, at the end of the day, it's our charge, and I won't say this correctly exactly, I'm sure, but it's our charge to protect the citizens of Texas. And part of protecting them is to make sure that the people who go out there and deal with them day to day and show them houses to lease and to buy and put their houses on the market to sell, that they know enough about what they're doing to get those people the best price possible in the current market, to keep them out of trouble to the best of their ability. And you know what? Just to make a professional transaction. That is an important thing, and that's at the end of the day why I think most of us up here at least bother to volunteer our time to do this. And it's tough. But from a personal standpoint, coming with a lot of years of experience, I think I can tell most times whether the people who come to work for me, because as a broker and manager through the years, I hire people, I bring them in, I train them, I develop them. But I'm often working with them through the training process. And I know the struggles that many, many of them have when they are not in a situation where they are getting good training, where they can ask questions, where they're just thinking that they get the same thing from this course they bought online that they would get being in a classroom. And I know how many of them at the end of the day, after they flunk the test a couple of times because they flat didn't learn what they needed to pass it, have to go to a class and sit in it. Or how many will say, I think I'll just take my class as correspondence, but then I'll go to a prep class or two and sit in the classroom. There is something you get in that classroom component or where you can interact with an individual. And I cannot just sit back and watch what we have happening continue to happen. I have all of the empathy in the world for the individual for whom the expense is a difficult thing. But maybe real estate isn't for them right then, because let's face it, it's a commission business, and if you don't have any money, it's tough to get in it to begin with. I have all the sympathy in the world for the people in the military. But you know what? Maybe they can come back and they can take the classes here. So at the end of the day, I come down to how can we best provide the kind of trained individuals for the people who live in the state of Texas to work with. And based on all and everything, if it's appropriate, Madam Chairman, I make a motion that we approve what's been presented today and to pass it forward for comment.
I have a motion. Do I have a second?
Second.
Okay, we're going to take another comment. Commissioner Westcott?
Yeah, I've got a question I'd like to ask this
Okay.
woman. I'm going to ask you the same question I asked the previous speaker, and that is along the lines of Ms. Morgan's contention that there are no facts that support the correspondence courses produce inferior agents or more unethical license holders. Do you have any facts that support that contention?
I think that to answer your question, no, and we raised that very question and asked Mr. Oldmixer, are there any statistics that indicate that there are more TREC complaints from someone who's gone to a correspondence course or regarding passing the test? They're not out there, and maybe that's something that, as an industry, we want to look at. But further, in answer to your question, it is the quality of those materials and the fact that the passing the test is step one. What does that tell us about that person? Only that they could pass the test. Working with a consumer, providing all aspects of being an excellent real estate agent is what it's all about. We question that the person who has only had the ability to read a manual, pass a test which is sometimes provided with that manual to them, is not getting the same quality and completion of education as someone in a classroom or online environment. There are other resources. We seriously question the quality of the correspondence course.
And I appreciate that point of view, and my opinion leads me to agree with most everybody else on I think on the commission in that there are some serious issues with the quality of person that comes out of correspondence course. But it shocks me a little bit that ESAC is moving forward with this when there's no basis in fact that it does so. And so I would have expected, if we're going to make or at least propose a change of this magnitude, that there would be some factual basis supporting the contention that it produces an inferior license holder. So I'm just shocked by that a little bit.
Well, Commissioner Westcott, I think the facts you're looking for are statistics.
Yeah.
And the facts that we are dealing with is everyone on that committee is either a practicing broker or an educator. So they're in daily communication with students and the level of material. And they've been in the business for long enough to see that the source of the information and the quality of the student and the realtor coming from their offices where they have seen it in actual practice. So we don't have the statistics, we have a life experience.
Commissioner Turner has a question or a comment.
Hopefully a quick one. Ms. McCoy, have you ever completed any of your MC requirements via correspondence?
Not through correspondence and very few online. I've been in the business 35 years, so they really weren't available at that time. So no, I have not. I have taken, as I say, online courses because I wanted to see how they would be done. But actually completing one, we have looked at some of the materials, but I have personally not taken a correspondence course.
Are you a broker?
I am.
Okay. Do you have agents that work for you?
I am a director of professional development for a large brokerage. I've had my own company. I've had agents working for me. I have been a trainer for 20 years. So I've seen what the good and the bad of all of it. And from my personal opinion, now in an educational role, I feel that we are doing a disservice to the consumer and to realtors in general if we don't make this on a fair playing field. And it's not on a fair playing field. When you see that some of the instructors, and many of us on the committee, were ready to let correspondence, and myself included, I was ready to let correspondence stay until I kept hearing from staff and hearing from the actual instructors and schools. There was an instructor, one of the ads that I gave you, they brag at the fact in writing, which is a breach of advertising of 535, as I read it, that fine, take it in 15 minutes and pass at 3 hours. I'm proud of that. I'm not proud of that. I'm not proud of shortchanging the educational amounts that somebody is getting, or that other agent who sat there for 3 or 15 or 30 hours and did it right, did it the way you all want it to be for that amount of time, not taking advantage. I don't think that that's the honest trustworthiness and integrity that we want in our schools or in our agents, that they are going to find the way around the system. And that's wrong. And that's what's happening in correspondence courses from our research. They're they're shorting the system, and they're breaking the rules.
I have a quick follow-up. I take it from your background, tell me if I'm wrong, but you have managed an agent or some agents in your...
I have.
Okay.
Yes.
Did you...
I've been a manager in 4 of the largest firms in the city of Houston. I've owned my own company with agents. I am now the Director of Professional Development, which is involved with agent training.
Okay, I get... No,
oh, I'm sorry.
Sorry, I'm trying to move things along. I just want to know if you ever, in your capacity as a manager of real estate agents, did you mandate that your agents complete their MCE credits in some delivery system other than correspondence? To put it more simply, did you allow your agents to complete their MCE requirements via correspondence at the time you were managing agents?
Never mandated, nor do we now, the form of classes that they take. But I can say that most of them will take it online because they have the ability and the time, the computer to do it.
Mm-hmm.
So I think the type of choice that most of our agents these days want to take are the online, because the young ones coming up, they're so tech-oriented that they like the online. And the schools that do combine the webinars with the online and the webinars with the classroom, I think that is going to the needs of the adult of all ages, the millennial to the silent to the baby boomer. We have different needs of how to learn, and that's why the online and the classroom provide to those needs. I think we've left the correspondence behind us.
Ready to go.
And again, the tools to learn online, if you don't have it as a practicing real estate agent, are you really capable of servicing the consumer totally in this day and age?
Can you sum up for me, just as briefly as you can, what's the impetus from the committee to get rid of correspondence? Is it just the overarching concern that there are people who are completing these 15-minute exams for 3 hours of credit that they're somehow cheating, or that they're getting away with something? Is it just overall concern over the quality of those programs?
It's mastering the material, quality of the program.
If you can pass the test, haven't you mastered the material?
I beg your pardon?
If you can pass the test, haven't you mastered the material?
You mastered the test. You didn't master the material. If I interviewed that person who just passed the test and did it in a shorter period of time and never had a real estate background versus one who was in a classroom environment or online, my guess, and there are no statistics to that, will be able to deal with the situation better than the person who just read it out of the material. I think and what bothers the committee is that these agents may study to the test only, and they've passed the test, they have a license, but now they're going to be out in the community servicing the consumer, and that may be the last courses they take until they take their SAE, and maybe they're going to take those online, or maybe they're going to take those correspondence. And have they gotten the big picture of how serious this business is? How many complaints did we see that we get from TREC? Where are they coming from? If we give a further, more complete knowledge base for our agents, will we have less complaints? Will we have better agents? And will we have a happier consumer? And we question that when it comes to the material and the way it's presented and the options that a potential licensee has on the correspondence version.
And you believe those concerns are adequately addressed via online delivery, interactive classroom setting?
Yes, because we can't, I think everyone in this room who has in a school would probably opt for a classroom if they could, because then we know what we're getting. We know if they're participating, listening, and are sitting there that long. We certainly understand there's a possibility that somebody else could sit down in a chair and take a test online for someone. It's the real world. And hopefully that we're getting people into this business that are going to be honest and trustworthy and have the integrity not to do that. Can that happen? Of course. But at least they've had to look and sit in front of that computer and answer questions that will indicate if it's them or not. Mm-hmm. And at the end of the test, complete the course and complete the test and maybe have more information than they would have had otherwise. It's not a perfect situation. Classroom
I understand.
probably would be.
Yeah.
But we think of the three, classroom, online, and lastly, and possibly no longer, correspondence has its place in our learning model.
Okay, one last question, I think. Are you an instructor?
Yes, I am. I'm
Okay.
TREC approved for legal, ethics, core, and broker responsibility. And in my office, my company, which is 900 agents, I am the trainer for new agents. So I get them the day after they're licensed and do the continuing.
Do you provide instruction outside of your current job?
Yes.
Okay.
Yes.
Are you compensated? Do you make do you make money from being an instructor?
No, I don't.
Okay.
If we were to give courses, my company is an MCE provider. If we would give those courses and make them available to the public, we would not charge. So no, I have no benefit.
Okay. And we can just cut to the chase. I mean, there have been some obvious stakeholders here today who, if we get rid of correspondence, they're going to lose part of their revenue because they offer correspondence courses. So I'm just trying to figure out if you've got a dog in this fight, other than just the general integrity of realtor education.
That's what took our committee so long, because we have the appreciation for those companies, real estate schools, that might have to change their business model. But we all have to change our business models to keep up with today's economy, the real estate business. We're changing forms, we're changing contracts, we're changing everything. We have to change to keep up with what's happening in the real estate industry, to keep us all out of trouble. The better the practitioner when they get out of training and get their real estate license, the better off we're all going to be. But our committee weighed this very heavily. It was up to the last minute, but we did have a unanimous vote of those present that were in favor of the discontinuance of correspondence courses.
I'm sorry, I keep thinking I'm going to be done, but I've seen this issue is raised. I've received more emails, more attention with this issue than I think any other issue since I've had the privilege of serving on this commission, and so I'm really interested in getting to the root of this. And we've heard from some of the stakeholders today. How much did the committee hear from, if at all, from just licensees, brokers, or realtors? And if you can give me, just off the top of your head, assuming you did hear from licensees, where was the breakdown on support for or against these changes?
In the shortest possible answer.
Yes,
and
ma'am.
that's the last question.
And I won't ask you any more.
0 brokers or agents appeared at our January, April, or July meetings. If anything had come in online, I'm not aware of that. It was not brought up at our meetings. What we did get attendance at our meeting in April, there must have been 50 representatives from various schools that were there taking both positions. I will say more in favor of retaining the correspondence. And I wrote down, as I listened to other speakers this afternoon, wondering, why are they so vehemently opposed to removing correspondence unless it's got to do with the net income to their organization and not wanting to restructure what they're doing? They are doing excellent on online, excellent in classroom. I'm puzzled myself why they're fighting so strongly for correspondence courses when the entire picture of the reality of what it's all about does not equal the quality of education in a classroom environment or online. So why are they fighting so hard to keep it? I'm really not sure. We're only looking at the material and the mastery of the material and our view that it is an insufficient way to master this material.
Thank you, Diane. Thank you for. Please take back to your committee. We appreciate their hard work. I also appreciate all of the speakers on this subject matter today. I know that you're all taking time away from other things that could make you money to be here and make your opinions known, remembering, of course, that our job is to protect the consumer, and remembering, again, commissioners, before we take the vote, that this is the opportunity to post this and get even more comments, and perhaps ESAC will certainly, at their September meeting, September the 30th, I believe, at 10 o'clock, review comments that come in, assuming we move forward on this proposal, and perhaps modify what they have proposed. We've heard a lot of good things. I would tell you, those of you who are public appointees, that we're in a painful process. We have long, as the Real Estate Commission, held the sort of image that all we cared about was whether or not you could pass our licensing test, not whether you actually learned anything in your education to get there. And we're in the process of moving in a direction where what their pre-licensing education, that we have some new name for, actually teaches them some content mastery, so that when they get a license, they have some minimal level of competency before they hang their license with you or me. And that's the process that we are in. I have a motion. I have a second. All in favor say, whoa.
Can I just clarify the motion?
Yes.
Because I want it understood that we're talking about all of
All
Chapter
sections.
535 and the proposals, new rules, and repeals. Just wanted to clarify.
All of 18, all of agenda item 18. All in favor say aye.
Aye.
And opposed, no.
No.
Motion
Chair,
motion
I'd like to point
carries.
out that the reason for no is that we're opening a Pandora's box that I think we're unprepared. The Education Committee has done a lot of work, but I really believe that the right questions were not asked to the right people, and that's the only reason I
Opportunity for them to review that at their next meeting. Agenda item 19. I have two speakers also. One speaker, one opinion.
Okay, agenda item 19 is discussion and possible action to propose amendments to 22 TAC Chapter 537. It's for the full chapter in terms of quadrennial rule review with the terminology changes and revisions for clarity, but there are two substantive changes coming forward today. One is in section 537.11, the use of contract forms, and that is in subsection O, is revised to prohibit a computer file or program version of the standard contract forms to allow an end user to strike through the text of the promulgated form, and also to clarify that blanks can be scalable for when terms are inserted on those forms. I will say the broker-lawyer committee reviewed this at their last meeting, and unanimously both brokers and attorneys made this recommendation to not allow the ability to programmatically strike through the forms.
Carrie, is a blank, is paragraph 11 a blank?
I guess it would be a blank.
Okay.
But it's a space to be filled in.
Okay. Okay.
Remember, this again is just a proposal.
I understand.
Refinements can be
Okay.
made, suggested.
Commissioner Martinez.
I'd like to make a motion on this.
Well,
I'd like to-
okay.
Or you're not done?
We're going to do them one at a time. That's fine. Great.
Ready?
We're only going to do the HOA, I guess, or the rules. Is that what we're doing, the rules?
The rules.
Go. Martinez.
Okay, move that staff is authorized on behalf of the commission to submit the proposed amendments to 22 TAC Chapter 539 as presented, along with with any technical or non-substantive changes. 437. Thank you, Commissioner Westcott.
We're proposing to the Texas Register. Oh, that's the next one.
Thank you, I was on the wrong one. I move the staff is authorized, so I've said all that, to 22 TAC Chapter 537 as presented, including the form adopted by the reference in 537.51, along with any technical and non-substantive changes required for proposal to the Texas Register for publication and public comment.
Second.
And I'm saying, and then you want to finish your comments about the
Yes.
form?
Yes, because we
quickly.
Okay, so this is the new form we talked about previously. It's a new addendum for reservation of oil, gas, and other minerals, which is being recommended by the Broker Lawyer Committee, which originated from a committee that you heard from earlier today, one of the attorneys on that committee from TAR. So, and staff recommends the adoption for proposal of that new form.
Mr. Doak has offered his in favor of this, and Mr. Johnson is here in favor of this and has also offered to answer any questions that you might have about the oil and gas addendum. Do I have any questions about this proposal? Thank you, Mr. Johnson, for your attendance. All in favor say aye.
Aye.
And opposed, no. Motion carries. Agenda item 20 and 34.
A discussion and possible action to propose amendments to 22 TAC Chapter 539, provisions of the Residential Service Company Act. Again, this is put forth following our quadrennial rule review to better reflect processes and to improve readability. Subchapter D was amended to add definitions, and Section 539.140, the Schedule of Administrative Penalties, was also revised to include statutory and rule provisions that were previously inadvertently omitted. Also, new forms that are under your tab 34 for the annual and mid-year review are being proposed by reference under this rule.
Agenda item 34 is on page 349.
And those are the new forms that are being presented, proposed through adoption by reference in this rule.
So I would entertain a motion from page 243 and to 349.
You could actually just do the motion on
364.
243 and just say including any forms adopted by reference.
Okay, so Mr. Halley is going to say that and add the forms to it.
I have a motion to move that the staff is authorized on behalf of the commission to submit the proposed amendment to 22 TAC Chapter 539 as presented, along with any technical or non-substantive changes required for proposal.
And the forms.
And forms, great, to the Texas Register for publication and public comment.
Have a motion, have a second?
Second.
All in favor, say aye.
Aye.
Opposed, no. Motion carries. Agenda item 21.
Discussion and possible action to propose amendments to 22 TAC Chapter 543, rules relating to the provisions of the Texas Timeshare Act. Again, these are proposed from our quadrennial rule review, and staff recommends proposing the amendments as presented.
Commissioner Hensley.
Madam Chair, I move that the staff is authorized on behalf of this commission to submit the proposed amendments to 22 TAC Chapter 543 as presented, along with any technical or non-substantive changes required for proposal to the Texas Register for publication and public comment.
Second.
Have a motion and a second. All in favor, say aye.
Aye.
And opposed, no. Motion carries. Agenda item 22.
Discussion and possible action to propose the close of the review of Chapters 535 and 531, which we've completed our review of these chapters.
Madam Chair.
Arriaga.
I move the staff is authorized on behalf of this commission to close the rule review of 22 TAC Chapter 535, general provisions, in Chapter 541, rules relating to the provisions of Texas Occupation Code Chapter 53.
Second.
Motion is second. All in favor, say aye.
Aye.
And opposed, no. Motion carries. Agenda item 23.
Discussion and possible action regarding the Real Estate Recovery Trust Account and the Real Estate Inspection Recovery Fund. The Executive Committee reviewed the financial status of the trust accounts at their last meeting and found that there are adequate funds to cover all contingent liabilities, and no action regarding assessment need take place at this time. The committee will also be commencing a review with staff of proposed revisions to the text of the statute to better define the scope and purpose of the real estate trust account established by the legislature, and to determine whether the Inspector Recovery Fund currently serves the purpose for which it was established. The Executive Committee will bring forward recommendations to the Commission at a future meeting.
Thank you. Ms. Lewis, any questions? Nope. Okay. Mr. Olmixon, I believe you have 24 and 25.
Yes, I do. Thank you, Madam Chair. This next agenda item is the 5-year strategic plan for the period FY 2015 through 2019. The primary goal of this biennial project is to assess the agency's progress, seek extraordinary input from our stakeholders, take stock of the challenges we face, and propose solutions, both near-term for potential legislation, rule, or policy, and long-term for process development. This year's planning effort included all of the above. The process for public hearings and summaries of the inputs received are in the report that you received. The agency's mission, philosophy, goals, and strategies were all reviewed and updated. Some new measures were added to better align with the state benchmarks and revised goals and objectives. So progress over the last 2 years was documented, and areas of needed attention and enhanced effectiveness were noted. So in addition to the general goals of, 1, completing our imaging project in 2015, thereby actually freeing up file room space and reducing our footprint for which we have to pay rent, so reducing our rent as well. Developing 100% of our processes for online 24/7 access, and then our improved websites. These are overall items that are mentioned in there. There are several items specific to the Commission that are noted in the plan that I would like to just touch on briefly. First is improvements are needed to the recovery fund, and also that's the real estate recovery fund, and revisit the effectiveness of the inspector recovery fund. Secondly, seeking disclosure protection is needed for investigative work product until after the investigations and the hearings processes are complete and a final order is entered. Third, we have long been treated differently than many other agencies that are subject to the professional fee in that the unfortunate choice of language in the one word in the statute actually causes us to collect the effective occupation tax on folks not practicing their occupation. So on inactive license holders, and that should be looked at, as many other professionals are exempt if they put their licenses inactive. Fourthly, to add, and this was there was a general call and enormous consensus around the fact that we needed to add a continuing education program for our promulgated contracts. The update, which we update at least every 2 years, and to provide those updates in the form of a course, and also to set, hang on one second. Oh yes, and to set a cap on the total hours of CE that we're allowed to require of our license holders. There is currently a minimum, but not a maximum. and that's probably was not intentional. So that needs to be fixed. So after your action on this plan, we will begin the discussions with our external stakeholders as necessary to begin development of the legislative elements of the plan. And at the Commission's proposed November legislative workshop, these matters will occupy a central place on that agenda. And I'd be happy to answer any questions, but overall, the staff certainly recommends that the Commission approve the strategic plan for publication as presented.
Turner. Commissioner Turner.
Madam Chair, I move that the Commission approve the agency strategic plan for fiscal years 2015 through 2019 as presented.
Second.
A motion and a second. All in favor say aye.
Aye. Aye.
And opposed, no. Motion carries. Mr. Olmixon, are you also doing the budget?
I am doing the budget.
All right. Agenda item 25.
We had the opportunity, of course, at the May meeting of the Commission to review the initial draft of the budget. At that time, the Budget Committee reviewed it, and of course it was presented as a draft in your materials at that time. Input was received from a couple of questions were asked. The second and third drafts of the budget were developed over the summer, working with the Budget Committee. You heard the Budget Committee report, the procedural report earlier, but I'd like to give, if appropriate at this time, the Budget Chair and Budget Committee members, if they want to make any particular remarks about the budget, I'll be happy to answer any questions.
What I'd like to do at this time, Commissioners, if you'll take notice of the documents before you, and we'll just kind of if you'll just look down there, you can see that it's very straightforward. I'll tell you that in the process of doing that, we covered a lot of ground. We asked a lot of questions. All of the staff was very cooperative in getting us the information and pushing hard to maintain a lean budget, but a very effective budget. And so I'm very pleased with what we have here today. What I'd like to do is ask Mr. Olmixon if you'll go through some of the highlights that we talked about so we can be as concise with our time as possible, and then we'll move to a motion and a recommendation as part of that motion.
Okay. Thank you, Commissioner. There are three specific topics that I would like to focus on. One is that the first is that the revenue projections contained in this budget reflect reductions in all classes of license for renewal. So reduction in the fee for renewal of all classes of license. And so that is something that we're very proud to be able to offer. There are a few adjustments also in the initial licenses, and some corrections in the treatment of reinstated licenses as initials. Those are brought onto par. But for the most part, every license holder at the time of renewal, real estate license holder, will see a $6 additional reduction in their fee for that 2-year period. As you recall, last year at this time we incorporated a $4 or $2 per year reduction, and so this $6 reduction essentially reverses the $5 per year initial fee increase that we asked at the beginning of our journey into SDSI status. And so this is effectively reversing that and returning us to the status quo ante. So we're very pleased that to be able to recognize that, in fact, we are able to operate leanly and do not need need those additional funds. Any questions on that? Okay.
Commissioner Arias?
Just overall, apparently we estimated a 5% increase in salaries and merit increases. Is that correct?
They're 4%. I believe it's 4% total in there.
What I did was take column number 3, which is budget for 2014, divided into the last column, which is budget variations. And I came up with 5%. My math might be wrong. But in employee benefits, it came out at 17%. We got an increase of $266,000, and our budget source of $1.525 million for this past year.
Yes, it is.
What would benefit go up to 17%?
We pay all of the health care costs for every retiree who has ever worked at this agency, retired from this agency. And of course, as I think everyone is aware, health care costs across the board are one of those that have defied effective control for the past decade or so. And that is continuing to rise.
So we're just starting to do that, or we've always done that, and the increase of healthcare has really increased that much?
We've always done that. We had specifically had several retirements. I want to say we had 6 retirements at the agency in this past year, and so that jumps up a big bump in 1 year.
I guess all agencies are having to cope with that.
They do. It's hidden for the most part at agencies, but we as an SDSI agency, it's front and center because we have to pay it. We actually have to transfer the funds.
Is our health care the same thing, the same one as the one the state does?
Yes, it is. It's identical. We participate in all of the state benefit programs. Yes, we do.
Thank you.
So that's number one. The second thing that I would point out, and it's actually found on page 2 of the budget under the projection of cash balances. You will see that the Budget Committee has proposed 2 new reserve accounts. So the very first reserve account is for current operations and contingencies. That's the one we have always had, that this body has a policy that we have no less than 3 and no more than 4 months of average total budget operating expenses reserved in that account for current operations and contingencies. So if we had a server go out or something like that, or something that we didn't anticipate, a fall off in renewals below what we had projected. Although we're very conservative with all of our numbers, both on the expense side and the revenue side, and have been consistently coming in the black, more than has been shown on any budget, so more than our projections for quite a long time. But that's what that amount is for. In addition, there are 2 new reserves recommended. The first one is reserve for long-term facilities master plan. So this is a reserve that acknowledges that there is, as an SDSI agency, we pay rent here. Obviously, our overall objective is to have our cost of occupancy as low as possible. So for the same reason that you most likely own your own home versus rent a home, it's actually less expensive in the long run. So our cost of occupancy, we would like to see that reduce over time. There is an opportunity that we have become aware of with the Facilities Commission to develop a small parcel of land here in the Capitol complex that would otherwise not be developed. In other words, it would remain a surface parking lot and nothing else, because it can only support about 25,000 square feet of office space, which happens to be about what we need. And if we pay for the development of it, then that facility then essentially belongs to us, but we are an arm of the state of Texas, and so it still belongs to the state of Texas, and so it's a win for them and a win for us, but it actually reduces, in the long term, we believe on pro forma, it reduces our occupation expenses. So we have begun initial feasibility discussions with the Facilities Commission for the long-term planning for that site. Okay? I will tell you that Mr. Alley, who spends quite a bit of time doing development work, has some great ideas for how to fund some of that development. But all this does is allocate. It's obviously, if it's long term, we need to begin to save for it long term, and so this reserves a certain amount of our available capital and dedicates it to that process, because there will be some costs with feasibility. But what I can assure you of is that no monies will be released from this reserve without this body's full acknowledgement and vote. Okay, so this is only creation of the reserve. This is not an authorization other than to proceed with the feasibility discussions with the Facilities Commission. Any questions about that?
Yes, sir. I think I understood. We're starting to save money to build our own building.
Correct?
Are we going to see the numbers before we start the feasibility period, or are you going to see the numbers after the feasibility period?
The feasibility is the pro forma, development of the pro forma up front. You'll see it all before there's any commitment.
I'd like to see that before we do that.
Oh, absolutely.
Thank you.
Commissioner Arriaga, and what's going to happen momentarily is I will make a motion to adopt the budget, and in that motion, I'm going to recommend that Commissioner Alley be charged to work as a liaison with the Facilities Commission to develop essentially that pro forma for us to review. So that way, in the very near future, we can come back with a 3-page packet explaining here's the nuts and bolts, here's the brick and mortar costs, and then we'll start diving into what the reality looks like. So
if it's possible, I'd like to serve with Mr. Alley in that committee.
Okay.
Okay, thank you.
There is, I will tell you, I did this same presentation last Friday for the board, for the appraiser board, and although their participation is proportionally much smaller, they also had 3 individuals who raised their hand and volunteered to serve on feasibility. The chair limited it to 1 only because this is a marathon. There are so many, the Facilities Commission, the Governor's Office, the General Land Office, the Historical Commission, and the Capital, well, I forget what it all, but anyway, there are so many different agencies involved with doing any development, which is why there has been so little development in the Capitol complex, because it is really difficult. So it will be a very measured opportunity, and there will be plenty of opportunity for lots of in-depth participation as this goes forward. Okay. Anyway, that's just to share that with you. Any other questions on the Facilities Master Plan? Okay. The second recommendation is for the creation of an educational development fund, reserve fund. This has to do with some initial planning for filling a gap for something that does not currently exist today. And that is, in many areas of public policy, there's a keynote event, educational event, a summit, if you will, held for in a whole variety of areas. For example, there is a Texas Rural Land Summit, There is a Texas Taxation Summit. There are litigation-related, many areas of policy. There's a definitive event that has to do with bringing all the players in the areas, all the various agencies and private partners together, or private sector partners together, to talk about what's going on in the industry, what are the challenges, how does the public and the private together address those challenges to move our economy, or move that sector of the economy forward. There is no such thing for Texas residential real estate. Not yet. This is meant to provide the seed corn, if you will, for developing just such an event with the Texas Real Estate Research Center at Texas A&M, who obviously brings an enormous amount of professionalism, that professional respect, and then of course also with our the professional associations of our stakeholders. But we're looking at essentially planting the seeds to have our first conference like that, full-day conference in sometime in 2016. That's what that's for.
Is there any way to do that without the Aggies?
No, sir, there's not. Sorry. We couldn't possibly think about doing it without our Aggie brethren. Any questions about that? Any questions in general on the budget?
Mr. Olmixon, I'd like to ask Commissioner Hensley if she would like to say a few words based on the process that she reserved earlier.
I would. I first would like to just comment and thank Mr. Olmixon and congratulate him and his staff for a job well done, because before we sat down and actually met as a committee, you know, if you've ever put a budget together and you're cutting fee income, you certainly have to make the right assumptions to make sure that the volume of what's been happening in our organization for years is going to continue, because you're making a prediction that okay, I can cut this, but we've always received this, and so that will offset. And so, you know, as we ask the questions of where did you get the licensees, you know, the annual units, if you will, that are going to renew, how did you get that number? Because that's really the big number in trying to cover the reduced costs for our licensee holders. It was with great, it was a very long equation, and I can't repeat it because I really didn't understand it. So for me, and just conceptually speaking, I said, well, you know, it really would make sense if we looked at the last several years, and that's part of the equation, but they said it much more complicated. I said, can we just look at the last 5 and make sure that that's an average, that we're not going to get any higher than that in predicting what's going to happen, because we have had a lot of things happen over the last several years that have spiked licensee holders, particularly brokers and such. So anyway, with those questions and comments, they expanded the budget line and showed where they had actually gained those numbers. And like I said, my compliments to them, because they had really every single answer that we asked them. So lots of detail and lots of work to come to the committee. So
thank you. And Commissioner Alley?
Well, I just have to echo the thought that the budget, as you went through it, was meticulously done, and I can quite say that issues about changing budget numbers are concerned, but I think overall there was a good effort to really come up with a budget that made sense, and I'm really proud to be on this committee to see where the numbers fall out, and then you still have revenue to support the expenses that you anticipate. And, you know, typically, I wouldn't consider myself a lean and type of guy in terms of doing it, because nature of my business, you kind of always looking very positively projected. But we came out with a budget, even being very conservatively looking at, we still look at some really good numbers for the future. So I'm glad about what we came out with. Good job.
And Commissioner Alley, would you mind just give a 30-second blurb on just your background and one of the reasons why we're going to recommend that you work with the facilities group, just for the benefit of those in the audience and listening?
Well, I have a kind of mixed background, but just to say I started off in engineering, and I went from engineering into development and everything from residential. Primarily now we do office buildings and hotel developments. And what I always saw is it's a way in which we can get good returns based on assets that we have. And, you know, when I talked to Douglas about how can we take the assets which was cash flow that we have here now and make it into an asset, you know, I just thought it was just the perfect deal. So I'm really anxious about the possibility of us having a building with TREC's name on it and get some of these powerful real estate people to be contributors and put their name on it, and get some branding on it, and get some cash flow, because I think where we stand right now, we really have the opportunity to take advantage of license holders that are going to be real stakeholders in the whole TREC system. So I hope that, I know that it might take a slower than normal process, because when you're dealing kind of with public entities, it's slower than maybe private, but I'm quite certain that we're going to come out with something that everybody within the real estate community is going to be proud of when we are able to do this.
And if there's no other questions, then I'd like to move forward with a motion at this time. But before I do that, again, is there any other questions by the commission members or anybody appropriate?
I'd just like to say thank you, not to overextend this, but I'd like to commend the commission members and staff that were part of this budget committee. You guys did a great job, and not everybody, it's hard to wade through numbers like that, so thank you very much.
On behalf of the committee, thank you, and you're welcome. So at this time, I'd like to go ahead, I'd like to make a motion that the commission adopt the budget as presented. As part of that motion, I would like to direct Commissioner Alley to serve as a liaison between this group and the Facilities Commission, and I'd like Commissioner Arriaga to be the designated proxy for Commissioner Alley in the event that he is not available to attend, and I would encourage them to speak on the matter jointly as a means to move us forward as expeditiously as possible. If I could get a second to the motion, I would appreciate it.
Do I have a second? All in favor say aye.
Aye.
And opposed, no. Motion carries. That takes
Thank you,
us-
Commissioners.
Yes, thank you, sir. Then we've already done agenda item 26. I believe agenda item 27 has been pulled. Is that correct or not? I'm sorry, come forward, Ms. Huerta. And thank you for all your work on what we just did.
Oh, you're very welcome. Melissa Huerta, Director of Staff and Support Services. And Commissioner Ariac, I just wanted, Doug explained about the retiree insurance, but I just wanted to let you know that it's not a percentage of the salaries, and so that's why it's based on whatever the cost is for the insurance for that particular retiree. And this past year, as Doug said, we did have 6 additional retirees that we're paying for, and we currently have and are expected to add in fiscal year 15, we'll have at least 14 additional staff members that are eligible for retirement. So if they all retire in 14, all those costs will be added to that retiree benefit.
Makes sense, but the 17%, if my numbers are correct, is what sort of was a little red flag that I saw.
Right, yes, no, I understand. So I just wanted to explain it a little bit more. And on agenda item 27, the report is in your materials, but as Doug said earlier, it was pulled by the State Auditor's Office, and so they're going to be revising their report, and then they'll be presenting it at the next commission meeting.
Any questions for Ms. Huerta on this matter? Thank you.
Thank you.
Agenda item 28, broker responsibility course, which you were sent as an attachment. Does anybody need to?
Clear? Good.
That is correct. You all should have received this by separate email. It does include instructor discussion and answers, so it's not on our website for that reason. At this time, we're asking for approval of the proposed second edition of the broker responsibility course, which has been redesigned to track the provisions of Rule 535.2 regarding broker responsibility. This, like I said, what was sent to you was the teacher's edition, and there will be a teacher's version and a student version. The student version will not contain the teachers' pages, but having this additional discussion and answers in the teacher's version will provide for more consistency in instruction of the materials, and the interactive design of the course hopefully will encourage discussion that draws on experience from brokers in the room, again, to help with learning and retention. At this time, we request that the broker responsibility course for 2015-2016 be approved as presented.
So moved.
Madam Chairman?
Madam Chair,
Yes.
Whatever.
is that going to be
Second.
available through correspondence?
Currently, it would be.
I heard
I have
that
a
question.
motion and a second. All in favor say aye.
Aye.
Opposed, no. Motion carries. Agenda item 29.
While she's walking up, I'd like to let the legal counsel in the room know that I'm planning on now taking the bar exam without going to law school. Because I know I can pass it. Yeah.
Because you're smart, and you know it.
On agenda item 29, again, my name is Melissa Huerta, Director of Staff and Support Services. I didn't know I have to do that every time. But in front on your dais, there was this form. And so what we're asking is that if you could fill it out and elect whether you want to receive the per diem reimbursement or the travel reimbursement for each of the commission meetings, and also for any qualifying committee meetings. And we just wanted to make it easier on staff because everybody chooses something differently every time, so this way it can be consistent. If you want to make a change during the year, you're always welcome to submit a new form to make the change.
What are you paying us right now?
It's $75 per meeting, and then plus your travel reimbursement.
And you can't just automatically say no and say, give this to the building fund. I would have to take the money and then write a check back, right?
Yes, ma'am.
Okay.
And I guess some people don't feel that's proper, or
Some people just don't choose to get it, but with staff, it's just hard because then we have to remember who wants it and who doesn't want it, and if we have it filled out on a piece of paper, we know.
And Commissioners, the reason that we're doing this, for almost every commissioner and public appointee, takes the per diem for this meeting and their expenses for this meeting, but this also covers the committee meetings, and so you could make a different choice for those if you like. And so that really just gives us the opportunity, instead of having to ask every single time, to just look at what your election was, and of course you can change that at any time. We'll just look at what you have in writing.
Yeah, we're on 29. I need a motion.
Madam Chairman, I move the commission approve the statutory per diem and travel reimbursement policy as presented.
Second.
All in favor say aye.
Aye.
Opposed, no. Motion carries. Agenda item 30. 3-0.
Carrie Lewis, this is discussion and possible action concerning coming soon or pocket listings. This issue has caused some concern in the industry, and so in your materials we included a discussion of some of those concerns, as well as a policy position put out by another jurisdiction. Just want to point out that TREC does not regulate listing agreements or MLS contracts. However, TREC does have jurisdiction over advertisements and ensuring that license holders don't violate their fiduciary responsibility to the clients. The Executive Committee did look at this issue, and I don't think any action is recommended at this time. However, they will be looking at the coming soon signs in terms of possibly how it might be addressed in the advertising rule, and staff will be putting an article in the advisor reminding license holders of their fiduciary duty in conjunction with coming soon or pocket listings.
Any questions or comments? No. Thank you. Agenda item 31.
31, again, is something that's new in the industry. It's discussion and possible action regarding .realty as a domain name, and so this new domain name for URLs of .realty is now available and can be purchased by people or companies. TREC does not control or regulate who can purchase that domain name, and right now the Commission's current advertising rule does not regulate URLs. Once you get to the page of that URL, all of that content is included in our advertising rule. So right now, the issue is just one being brought to your attention. It will be studied in connection with a comprehensive review of the advertising rule. No action is required.
Any
at this
questions? Thank you. Agenda item 32.
This is actually an item that was brought forward at the request of Mr. Martinez. I just want to make a few notes, and then I'll turn it over to Mr. Martinez. First, I'll note that in our applications for a license, we do already have them certify that they are either a U.S. citizen or a legally admitted alien. However, on our contract forms, which are brought to us, recommendations are brought to us by the Broker-Lawyer Committee, historically, we have not included any type of identification as to foreign citizenship for a couple of reasons. One, there's no prohibition in this country from foreign citizens owning property in the United States. And two, just by putting that information in, it might create the potential for a claim of discrimination under the Federal Fair Housing Acts, so laws and acts. So that's sort of just a summary, Mr. Martinez.
Before he starts, I just want clarification on what exactly we're talking about doing here. Is this disclosure for participants in a property transaction, each one saying what citizenship they have, or the broker, or who?
Mr. Martinez, do you want to address that? I think the request was for the contracts.
So what I'd like to have done, and I did, including the word foreign, it needs to be struck from the agenda item. Very simply, I'd like the citizenship declared of the in the transaction itself. My concern is that, to protect the property rights of the folks that are in the state of Texas that own property, regardless of where they're from. Okay, let's just say it that way. But as they go through that contract and they're going through with a purchase of a piece of property, I'd like for them to be able to simply know who on the other side of the contract, what laws they fall under and what laws are they ultimately subject to. I know that in the industry, I've heard people say, well, to prevent yourself, to protect yourself, you just get a big escrow, before you move through with the piece of property. And, ultimately when I look at that, I think that we can do better than that for the property holders in the state of Texas. I think that I'd like to hope that by having a little more disclosure, maybe we also see fewer recovery fund cases, because again, I just want the people that are doing the transactions to know who they're dealing with on the other side of the ball. So again, I strike the word foreign because that's not important to me. I would just like for them to know, again, what their citizenship ultimately is from, so that they know where ultimately they fall under jurisdiction-wise.
Any comments?
Yes. I will forward to you a study that the National Association of Realtors does every 2 years about foreign investment in the U.S. in residential real estate, because it's hard to measure commercial. I think this is going to be some groundbreaking information that will put Texas in the very forefront of how we help promote Texas, not only internally but externally. So I think it'd be a great idea.
And I would only point out that there's no action on this agenda item, because if it's going to affect the contract forms, it's got to come from the Broker-Lawyer Committee. So I would suggest that these comments be forwarded to the Broker-Lawyer Committee at their next meeting.
But as we forward it to it would be nice to know if the Commission feels that this would be something positive as it goes to the review of the Broker-Lawyer Committee versus blase, hey, read this. So I would like to ask, just maybe by way of nod, does anybody oppose this being reviewed by the Broker-Lawyer Group?
I would only like that review to include potential legal liabilities with regards to the Fair Housing Act, because
absolutely.
That pricks my ears on that too.
Sure.
No comment with regard to the purpose or anything else. Let's just
absolutely
not create any potential liabilities for our agency or anything
absolutely
like that.
And that's part of the reason why it would go to that committee to review the suggestion anyway.
I agree with Commissioner Turner, and I'm glad he said that. That was something I was thinking about. There is a paragraph 20, I think, in the contract which speaks to the IRS obligations put upon a buyer when there's a foreign seller. And there might be an opportunity to marry up something, if you will, with what's already needing to be done based on what an IRS rule and what you're kind of wanting to accomplish. I don't know. Because in our world as a broker these days, we're struggling with whether or not we should have some sort of disclosure on a listing agreement that we ask every seller, not just some, but every seller, based on the IRS definition of a foreign person, do you meet this requirement? So that just only comment. Thank you. Agenda item 33. Oh, a new person. Whoa.
Give Carrie a break.
Her feet probably hurt.
Gwen Jackson, Director of Education and Licensing Services. Agenda item 33 is for discussion and possible action to approve new forms or changes to current TREC forms. And we've got 4 forms here for you. The first one is the renewal for easement or right-of-way registration by an individual or business, which is ERW RF-4. This form is being revised to require a signature and certification statement by the applicant or the business entity for individual or business easement or right-of-way registrant. The next form is the certification of completion of ride-along inspection continuing education course session form, INS-RA-CRT-1. It's being revised to clarify that it's to be completed and submitted by the education provider for the purpose of awarding continuing education credit to the students who participate. The next form is the certification of completion of ride-along inspection substitute experience course session form, INS-RA-SE-CRT-0. This form is to be used by the approved provider as a certificate of completion of the ride-along inspection substitute experience course session for qualifying credit and issued to the student for submission with an initial application. The last form is the certification of instruction of a ride-along inspection course session, which is form number INS-RA-INPI-0. And this form is going to be used by an approved instructor to claim continuing education credit for himself for having conducted a qualifying or continuing education ride-along inspector course session. And staff recommends approval of the forms as presented.
Commissioner Justice has agreed to read all this stuff.
Madam Chairman, I move the Commission approve changes to TREC forms ERW RF-4, renewal for easement or right-of-way registration by an individual or business, INS-RA-CRT-1, certificate of completion of ride along inspection continuing education course session, and new forms INS-RA-SE-CRT-0, certification of completion of ride-along inspection substitute experience course session, and INS-RA-INPI-0, certification of instruction of ride-along inspection course session as presented along with any technical and non-substantive changes.
I have a motion, I have a second. I have a second. All in favor say aye.
Aye.
Aye. Any opposed, no. Motion carries. Agenda item 35.
Madam Chair.
Yes, sir.
The commission will also be looking for volunteers to serve on a forms renaming committee.
Yeah.
Not me.
Well,
Any penny. Yeah. Thank you so much.
I know the general counsel was appointed to that.
I think it's the executive director. Do we have any discussion and possible action regarding any future agenda items?
We have our November meeting date already set.
Just getting ready to talk about that. There is a 34 we did earlier today.
I'm sorry.
We took that with 20.
So sorry.
No, thank you for reminding me to tell everybody that. 34 we already did with 20. Thank you, Commissioner Alley, for making that motion. Item number 36, possible future meetings. We face soon a legislative session that, of course, we don't lobby, but we do have some things we would like to do. And we were, as an executive committee, thinking if it worked in your schedule that we might move the November meeting to Tuesday, which I believe would be the 18th of November, and you came in a little early on Monday, the 17th, for an afternoon work session, workshop, and look at things a little more in depth here and there, and talk about legislative wish list stuff. And I want you to check your calendars to see if you could, in fact, do the afternoon of the 17th, which would pretty much take you out of the office 17th and the 18th. I need 5 people to say yes.
Yes.
I got 2 yeses,
Yes.
3 yeses,
I think I could probably.
4 yeses, 5 yeses.
Madam
That's all I
Chair,
need.
I'm sorry to back us up, but on agenda item 35,
Yeah, you have an item.
our off-agenda speaker today that brought up the potential for the creation of a rule that would allow for carryover of previously earned MCE hours. I'd like to see that added to the agenda or referred to the appropriate committee at some time in the future. I think there's some merit to that with some.
I did ask Doug to call him
Right.
and visit with him about it, specifically what his.
Put some control measures in place as far as time earned relative to claiming, et cetera, amount of hours, but I think that's reasonable.
I would be surprised if all of the seated commissioners don't take more classes than are required by law and don't carry over to next year. So I have at least 5 people that say yes to the 17th and 18th, so we're going to go with that. I'm sure good with that. Amen. We're done at 3:10.